Votre appel, s'il vous plaît, Madame le greffier.
Monsieur le connétable de Saint-Hélier. Madame le connétable de Saint-Laurent. Monsieur le connétable de Saint-Brelade.
Présent.
Monsieur le connétable de la Trinité. Monsieur le connétable de Saint-Pierre.
Présent.
Madame le connétable de Saint-Martin.
Présente.
Monsieur le connétable de Saint-Jean.
Présent.
Monsieur le connétable de Saint-Clément.
Présent.
Monsieur le connétable de Grouville.
Présent.
Monsieur le connétable de Saint-Ouen. Monsieur le connétable de Saint-Marie.
Présent.
Monsieur le connétable de Saint-Sauveur.
Présent.
Monsieur le député Southern. Madame le député Labbé.
Présente.
Monsieur le député Tadier. Monsieur le député Luce. Madame le député Dublé.
Présente.
Monsieur le député Morel.
Présent.
Madame le député Lehegara. Monsieur le député Ayer. Monsieur le député Ward.
Présent.
Madame le député Alves. Madame le député Gardner. Monsieur le député Ghost.
Présent.
Monsieur le député Farnham. Madame le député Moore. Monsieur le député Mezek. Monsieur le député Ozef.
Présent.
Monsieur le député Balash. Monsieur le député Coles. Madame le député Poré.
Présente.
Monsieur le député War. Madame le député Miles.
Présente.
Madame le député Scott.
Présente.
Monsieur le député Renouf. Madame le député Curtis. Madame le député Faltham.
Présente.
Madame le député Binet. Madame le député Jeune.
Présente.
Madame le député Miller.
Présente.
Madame le député Howell. Monsieur le député Binet. Monsieur le député Ferry.
Présent.
Madame le député Kovac.
Présente.
Monsieur le député Curtis. Madame le député Ward.
Présente.
Madame le député Wilson.
Présente.
Madame le député Stevenson.
Présente.
Monsieur le député Andrews.
Monsieur le doyen.
Notre aide soit au nom de Dieu qui a fait le ciel et la terre. Amen. Seigneur Dieu, Père éternel et tout-puissant, qui a établi le gouvernement et la puissance de la terre pour le règlement et pour la conduite du peuple, et qui nous a commandé d'avoir toujours pour but la gloire de ton saint nom. Nous te prions qu'il te plaise de donner à cette assemblée le don de conseil et de prudence, d'unir le cœur et les affections de tous ceux qui la composent. De la conduire toi-même par ton Saint-Esprit, que toute leur délibération est accompagnée de ta bénédiction. Réussisse au bien-être au soulagement du peuple, qu'il te plut de commettre à leur soin. Car nous t'en prions au nom et par le mérite de ton Fils bien-aimé Jésus-Christ, notre Seigneur, qui nous a enseigné à t'invoquer en disant: Notre Père, qui es aux cieux, ton nom soit sanctifié, ton règne vienne, ta volonté soit faite en la terre comme au ciel. Donne-nous aujourd'hui notre pain quotidien, et nous pardonnons nos offenses, comme nous pardonnons à ceux qui nous ont offensés. Et ne nous envoie pas en tentation, mais délivre-nous du mal. Car à toi est le règne, la puissance et la gloire, au siècle des siècles. Amen.
Madame le connétable de Saint-Laurent.
Sir, the Connétable de Saint Laurent is attending a funeral. Could I ask that she be excused?
She's intending to return to the assembly thereafter.
Indeed, sir.
Members agree? Excusez.
Monsieur le député Southern.
Défaut.
Monsieur le député Tadier.
Présent.
Madame le député Alves.
Deputy Alves is still on CPA business.
State's business.
Monsieur le Deputy Farnham.
Defoe.
Monsieur le Deputy Balash.
Sir, as explained yesterday, Deputy Ballas is still in the UK attending on a family member who is undergoing medical treatment. So,
Excusez.
Monsieur le Deputy Coles.
Sir, Deputy Coles is also still on CPA business. Thank you, sir.
State's business. Les États sont constitués.
So before we start, may I ask, I don't know if this is the right time, I have two propositions that are one after the other, and I just wondered if I could move one so that I have a short break in between the two propositions.
That's a matter entirely for the Assembly.
So I just propose...
Depends how merciful people
I
are feeling.
propose I propose to the very pleasant Deputy Max Andrews that I may move mine to before his, and I just wonder if you'd be happy with that. So thank you.
So this is P33 and P34, is it?
Yes, sir.
The hopper bus service and the Andium Homes.
Yes, so I wondered if I could move the Hopper Bus service just before the gender pay gap, just so that there's a short break in between the two propositions. Appreciate that.
That's a request to change the order of business, which is perfectly open to you to do. Is that seconded?
Yes, sir.
Does any member wish to speak on that? Andrews, you're the one probably most affected by it. No? Those in favour of making that small change to the order paper? Those against? Very well. We will take them in a slightly different order. Yes, well now we continue with the debate on P19. And does any other member wish to speak on the proposition? If no other member wishes to speak on the proposition, then I close the debate and call on the Minister to respond.
Thank you, sir. First of all, I'd like to thank members for all of the points raised in our debate yesterday. It was a really helpful and constructive debate. And without repeating points at length, I would just like to respond to a number of issues. I think, most importantly, I cannot emphasise strongly that the board doesn't diminish or interfere with my political oversight of the department. I remain accountable. I cannot also emphasise clearly enough that the matter at hand is not a statutory board or an arm's length organisation. The terms of reference before the Assembly were for an advisory board. I'd urge members not to judge this proposition on the basis of what you think about statutory boards in Jersey or whether or not they've been a good thing for Jersey. This is not what is before us today. The board is an advisory board. It was always constructed as one. And I inserted the word advisory into the title because I was asked for more clarification, to make more clarification. And as Deputy Renouf kindly noted, I listened and I responded, and it was suggested that inserting the word advisory had resulted in potential candidates not applying for the non-executive posts. Given that we've received over 110 applications for the 5 roles, and given the assurances I have received about the calibre of the candidates and the fact that their applications clearly demonstrate their understanding of the role of the board, I think the Assembly should be encouraged by the interest in what we're trying to do here. I also amended the proposition to place an explicit commitment on the board to meet with the Council of Ministers at least every 6 months. And this is because, in response to the points raised by Deputy Osif yesterday, it is recognised that the health and well-being of islanders is not a matter for me alone. It is a matter for all ministers, actually for this Assembly. So the board will collaborate with ministers, with Assembly members, with all relevant partners. And this isn't something I'm just reiterating now, but it is actually set out in paragraph 4 of the terms of reference. And what I want to assure Assembly members is that I, as the Minister, am actually committed to this collaboration. Deputy Jayan pointed out that the terms of reference include that the board will direct the department. Well, he's absolutely correct in that, because the board includes the executive directors who are currently responsible for directing the activities of the department. And this will continue, as members of the Assembly would expect. The Chief Officer of the department will, as a member of the board, continue to provide the direction in the day-to-day running of the department, but will do so with the benefit of the collective knowledge, advice and support of the board around it. This doesn't equate to the board determining health policy or strategy for the island. I do that as the Minister with support of both the Council of Ministers and members of this Assembly. Much has been said about whether the costs as set out in P19 are correct, particularly in relation to the Chair's remuneration. The costs in the proposition are correct, but it was apparent that the information provided wasn't clear. I clarified for members that the 2023 cost for the Chair's remuneration as set out in P19 includes both the remuneration of the fixed-term Chair and the substantive Chair that we will go to appoint on. Deputy Howell asked if the current fixed-term Chair is conflicted, and Deputy Jayan questioned both how much we're paying him and his contractual arrangements. I think we all understand that the terms of reference are not about one individual, as Deputy Ward noted, but I would like to assure members that I nevertheless have heard the concerns previously raised about potential conflict. And recognising that the perception of conflict can be as damaging as conflict itself, I have agreed with the Chair of the Jersey Appointments Commission that the fixed-term Chair will not sit on the selection panel for the non-executive directors. I would like to clarify the role of the Change Team. The Change Team are health service experts who are embedded in the department and are working along the senior executives. They are providing the executives with the additional capacity needed to deliver urgent reform, such as the development of a financial recovery plan. They're not filing an end-of-year report, nor are they responsible for the ongoing clinical and corporate governance of the department. That isn't their role. That is the role of the board. Some members spoke about an additional layer of bureaucracy, and I understand these concerns, but not a single member of staff or health provider consulted on the proposals has raised this concern with me. It has been exactly the opposite. They have all expressed support for the board. They want to see it in place. This includes the Change Team, whose work and expert members acknowledged during the course of yesterday's debate. Expertise members acknowledged during the course of yesterday's debate. The people in the system recognise that good governance removes layers of bureaucracy and ineffective management. It actually does not add to them. I accept, as it was said yesterday, that some members of the public believe the department is top-heavy. But it is also the case that the public are rightly outraged when we get it wrong. And as so well articulated by the Minister for Social Services, the costs of getting it wrong significantly outweigh the costs of managers, time and time again. So the board will cost. Health boards cost money the world over, but that cost is accepted in jurisdictions because it's recognised that boards are an effective mechanism for ensuring and assuring grip and control. There is no reason to assume why it will be any different here in Jersey. But if that were to be the case, we can change things in 18 months' time, thanks to the Chair of the PAC's helpful collegial amendment. And I would ask members also, please don't lose sight of the fact that the Treasury Minister tells us that the board represents value for money. No one more than me understands the need to get our health finances under control or delivering value for money. At this stage, I believe that the board offers a proportionate response to a very challenging set of circumstances. The Constable of St Lawrence is correct. It is the responsibility of senior officers to run the department effectively and efficiently. But we know that competent, highly qualified managers have not historically succeeded in delivering what we need. We could just keep blaming them, dismissing it as their job. But that hasn't worked, and it won't work in the future. So we need to learn, and we need to try something different from what has gone before. Independent oversight is critical to ensuring that the information we receive at face value is reliable and we can trust it. The Constable of St Mary specifically asked me if there had been liaison with insurance companies, and I apologise if I did not fully catch his point, but it is the case that there is a regular liaison with our insurance arrangements. What we do know is that when there are clinical failures, they are hugely costly. We need significant changes in our healthcare system for our patients and for our staff. No single member of this Assembly has refuted that point during yesterday's debate, despite the points of contention raised and the understandable concerns about the cost. It is also the case that no member of this Assembly has challenged the need to tackle the poor working culture in the department. You all recognise the need for staff to feel safe, respected and valued. Deputy Waugh raised the issue of trust and how important it is to build this trust, not only in our workforce, but also between the public and the service. This is going to be a key responsibility of the board. I ask Assembly members to support this proposition. The public needs to know and trust that we can deliver good healthcare. Deputy Luce talked about the need for solid foundations. I propose that this board offers the foundations needed to rebuild our health service and support our staff to do their best work. As the Chief Minister highlighted yesterday when recalling her own experience, the need to build clinical knowledge and understanding about what is happening in our healthcare system is critical to its success. This is a vote about whether we in the Assembly take our duty to Islanders seriously to assure them of safe services or not. As Deputy Morell put it yesterday, we have an urgent need to face the challenges of the future. Ageing population, workforce challenges, new diseases, new drugs, new treatments. We have to be prepared and equipped not only now, but for the future. And we need all the advice we can get from this board to help us navigate this. I urge you to vote for the board. Patients need it, our staff need it, and the island needs it. So I would like now to move to the vote.
Will you give way for a point of clarification, Minister?
No, sir.
Very well. You have your light on, Constable St Saviour?
On, sir.
Very well. The appel, do you call for the appel? The appel is called for. I invite members to return to their seats. The vote is on P19. I ask the greffier to open the voting and members to vote.
Sir, have we raised the defo? Sir, can we...
The defo is raised on Deputy Farmer. Yes. The voting is open. I ask members to vote. Members have had the opportunity of casting their vote. Then I ask the greffier to close the voting. And I can announce the proposition has been adopted. 28 votes pour, 16 votes contre, no abstentions. Very well. The next item of public business is the draft.
Can we have
Yes,
the
by all
16?
means. The 16.
Those voting contre, the connétables of St Brelard, Trinity, St Peter, St Martin, St John, Grouville, St Juan and St Saviour, deputies Luce, Lahegara, Ayer, Farnham, Rose Binet, Howell, Tom Binet and Barbara Ward.
Very well. We now come to the draft stamp duties and fees amendment of law number 6, Jersey regulations lodged by the Chief Minister, the main respondent will be the chair of the Corporate Services Scrutiny Panel. And
Sir, sorry to interrupt. I should have done it earlier. I just wondered as we go through today whether I can raise the issue of men removing their jackets when it gets too hot. It's reasonable at the moment, but the temperature's going up and up during the day. And I know for myself, at the end of yesterday, I baked all day, and I recognise your own attire, sir, and you're doing very well there. But
3 layers.
3 layers. But I just wonder whether at some point we do have to address this issue of comfort in the Assembly as well, because people are getting lethargic by the end of the day and it doesn't make for good decision making. So I just wonder if I can raise that. So, sorry.
The answer is I think it must ultimately be a decision for members as to the standard of dress within the Assembly. Traditionally, the Assembly has maintained appropriate standard of dress throughout, and I can't recall any occasion on which jackets have been removed, no matter how difficult it's become. But but that's simply, I can't recall it. That doesn't mean it's there or not. Perhaps it has happened in the past. I would suggest the right thing to do is to leave it for the time being, but if there's an interjection further along the line, the Assembly can take a vote for the purposes of this meeting only, and if arrangements need to be changed, then PPC, of course it does mean, what will the chair wear? I'm not entirely sure.
The last thing I wanted was a long debate on this, but it was just simply an appropriate time where the Assembly decided we just remove jackets. It did happen before when the temperatures were very high. It is very high temperature in here at times. As for yourself, sir, I think it's entirely your choice. I'll ignore the comment. I'll ignore the comment about a suit of armour.
Yes, I was about to say there is a suit of armour waiting at home. Deputy Scott, do you have a...
Yes, I just wondered if I could make a proposition to that effect right now. I know we are being filmed, but I actually think it would almost be a celebration of the fact that we can recognise that there is an inequity, that I am dressed like this, and and other members of the chamber who happen to be of the male gender are wearing jackets, sir. So I'd like to make that proposition if somebody's prepared to second it and if it's allowable, please.
Seconded, sir.
Well, a proposition has been made. I can't say that it's out of order. It seems to be in order because it's to do with the way the state conducts its business. Very well. It's seconded. Does any member wish to speak on the proposition?
So I think there are obviously 2 sides to this story, but I think however members decide to vote, I think it's good that it's being recorded for posterity, because I know that this is one of the recurring debates that happens in the Assembly, and when youngsters come to visit in particular, they're told about this debate that we have constantly about men having to wear jackets, the bailiff having to wear heavy, thick robes, and the women can wear skimpy tops, as Deputy Scott has put out. So
I think the proposition is only about men's and jackets. I'm not sure it's about ladies' attire at all.
So I think however we vote, I think it's good that there's a public record that the Gref now has some official footage of it, which I think Deputy Ward must have known as well.
Does any other member wish to speak on this proposition?
Sir.
Yes, Connétable.
So
Connétable St Saviour first. I saw your light first.
So, to my recollection, this has only come up once in the past, officially, when the then
Deputy Lamar asked the then bailiff, now Deputy Balash, if jackets could be removed as it is so hot. The then bailiff declined, and Deputy Lamar pointed out, well, the ushers are not wearing jackets. And the bailiff looked round and said, yes, but they're working. The attire was maintained.
Well, would never have occurred to me to say that. Thompson, Rob?
Thank you, sir. And at the risk of being pompous about this, I think we risk affecting the decorum of the chamber, and I wouldn't feel inclined to support the proposition. Thank you, sir.
Thank you very much. Deputy Dubray?
Thank you. So just to aid the constable's memory, I have raised this twice previously. The first time was with a previous bailiff, and that bailiff raised the standing order himself without any debate from members, and it was a very swift decision, and we moved on. The second time I raised it, we did have a debate which took a length of time, which I don't think we should do today, and I just think it's a matter of common sense, and I do think it is within your gift set to do it without debate, but here we are.
Well, it's now a matter for debate, so it's outside my gift now, I think, because it's a matter now for the Assembly. Does any other member wish to speak? Deputy Luce?
Thank you, sir. I won't be long, but I just wish to point out that if members think it's hot, it could get considerably hotter. This will not be a debate that ends just with removing jackets today. It will be a debate that ends with dress code for this chamber for time moving forward, sir. So I won't vote in favour of this.
Yes, Deputy.
Thank you. Very quickly, I will point out to the Constable of St John that if my decorum is so insufficient from removing my jacket, I shall inform him at the end of the day.
I'm not sure I understood that speech, but any other member wish to speak? No other member wishes to speak? Deputy Miller.
Sorry, I'm being slightly flippant, but perhaps we could look to our cold weather bonus and cold weather payment legislation and introduce a temperature chart for when jackets may be removed.
Yes. 24 degrees. There's not going to be a reference back motion or anything of that nature. Does any other member wish to speak on the proposition? No other member wishes to speak on the proposition? I close the debate. Deputy Scott, did you wish to say anything in response?
Yes, I thank members for their contributions, and I do very much I consider decorum has been respected insofar as members of the chamber, including me, arrived wearing jackets. If in the event that the vote isn't carried, I would also wish consideration to have the doors over there open just to allow people to work in a more comfortable atmosphere.
That's an entirely different issue.
And that would be a second proposition, sir, of course. Right. Thank you.
So
I urge members to support this vote.
Those in favour of removing jackets for gentlemen, kindly show.
Could we have
the appel is called for. Are we ready to open the voting group? Right, our vote pour is to remove jackets for this sitting only. It's of no general application. It's for this sitting only, and a vote pour is to remove jackets for gentlemen or leave to do so, and ask the greffier to open the voting and members to vote. Members have had the opportunity of casting their vote. Then I ask the greffier to close the voting. The proposition has been adopted, 29 votes pour, 13 votes contre, 1 abstention. I'm sorry, Deputy Miles, it didn't apply to ladies. The chair was being slightly flippant. The chair was being slightly flippant, and as I think the ladies can exercise a discretion about this without any difficulty at all.
So could we have the 13? I think it's probably one of the more interesting votes.
Yes, you can call the 13.
Those voting contre, the Connétables of St Helier, St Bralard, Trinity, St Peter, St John, Grouville, St Juan, St Mary and St Saviour, Deputies Luce, Gorst Andrews and Deputy Joseph online.
Very well. It would be arguably interesting. It would be arguably interesting to hear that vote broken down by gender, but probably that will be for the analysis on another day.
So I'm resisting to ask about waistcoats now.
I think that might apply only to me, so the answer is we won't do that. Very well. I think we've had all the flippancy the day can stand, and we're now on the draft Stamp Duties and Fees Amendment of Law Number 6, Jersey Regulations, lodged by the Chief Minister. Responder is the Chair of the Corporate Services Scrutiny Panel. I ask the Greffier to read the citation.
Draft Stamp Duties and Fees Amendment of Law Number 6, Jersey Regulations 2000. The states make these regulations under Article 3 of the Stamp Duties and Fees Jersey Law 1998.
Chief Minister.
Thank you, sir. The Stamp Duties and Fees Jersey Law 1998 contains regulation-making powers whereby the states may amend Schedules 1, 2 and 3 of the law. Schedule 1 is concerned with the scope and level of judicial fees and currently permits the Viscount to charge for certain services provided in connection with insolvency procedures, whereas other insolvency services are currently not within scope. These draft regulations seek to amend Schedule 1 to include certain further functions which are administered by the Viscount's Department Insolvency Team. These services are subject to practice directions of the Royal Court and are functions for which the Viscount currently has no statutory power to charge. The functions referred to are fully explained in the accompanying report. They relate to applications for aid in bankruptcy and insolvency matters and relate to recognition in or out of the Jersey court, degrèvement applications and assisting the jurats with remise de bien applications. The revenue that would be generated by these fees would be part of cost recovery, helping to offset the cost of administration of the functions. I should emphasise, sir, that the new fees being proposed, which are only one, the £45 fee for degrèvement applications would be fixed. The remaining fees would be discretionary, allowing the Viscount to take a view as appropriate depending on the circumstances. For each of these functions to which those draft regulations relate, applications must be drawn to the Viscount's attention ahead of them being filed with the Royal Court. The Viscount's role is to filter the applications and to draw to the attention of the applicant any possible errors or omissions prior to them being presented to the court. In addition, either the Viscount or a member of the insolvency team will be available to assist the court when applications are presented, which is especially important when they relate to contentious and or complicated matters. Sir, I move the principles.
Are the principles seconded?
Yes, sir.
Does any member wish to speak on the principles? Those in favour of adopting the principles kindly show. Those against? The principles are adopted. Does the Corporate Services Scrutiny Panel wish to scrutinise the matter?
No, sir.
How do you wish to deal with the matter in second reading, Chief Minister?
Sir, I shall make a brief speech, if I may, just to relate to the two draft regulations, which require little further explanation than I set out when I moved the principles. So perhaps actually we should take them en bloc.
Very well. Are they seconded for second reading?
Yes, sir.
Does any member wish to speak in second reading? All members in favour of adopting the regulations in second reading kindly show. Those against? Do you propose in third reading, Chief Minister?
Thank you, sir. Before I move to the draft regulations in the third reading, I would like to thank the Viscount and the senior manager of the insolvency team for their input and their cooperation in progressing these regulations. I move the regulations in the third reading.
Are they seconded for third reading?
Yes, sir.
Does any member wish to speak in third reading? Those in favour of adopting the regulation the appel is called for, invite members to return to their seats. And I ask the greffier to open the voting. The vote is on the adoption of P22 in third reading. Members have had the opportunity of casting their votes. I ask the referee to close the voting. The regulations have been adopted in third reading, 40 votes pour, no votes contre, no abstentions. The next item is the Draft Domestic Abuse Jersey Law 2022 Appointed Day Act, P23, lodged by the Minister for Home Affairs. The main respondent is the chair of the Children Education and Home Affairs Scrutiny Panel, and I ask the referee to read the proposition.
Draft Domestic Abuse Jersey Law 2022 Appointed Day Act 2000. The states make this act under Article 19 of the Domestic Abuse Jersey Law 2022.
Minister.
Thank you, sir. If approved, this Act will bring into force the Domestic Abuse Jersey Law 2022, which was approved by the previous Assembly on the 28th of April 2022. The key elements of the legislation are the creation of an offence of domestic abuse, which is defined in Part 2 of the law. Article 3 creates the new offence of domestic abuse with a penalty of up to 5 years' imprisonment and an unlimited fine. Domestic abuse will be an offence where both parties are personally connected. They are aged 16 or over, and on more than one occasion, one person is abusive to another. The abusive act or failure to act must cause or be reasonably likely to cause harm. We will also include acts committed outside of Jersey if the offender is usually resident in Jersey. Very importantly, the law captures behaviour which is coercive or controlling as abusive. And Article 4 requires a court that is sentencing a person convicted of domestic abuse to treat the presence or involvement of a child or a pregnant woman as an aggravating factor that increases the sentence. This recognises the significant harm to children from being exposed to domestic abuse. The second key element is the new powers for the courts to impose domestic abuse protection orders. This is dealt with in Part 3 of the law. Article 5 allows a court to issue a domestic abuse protection order against a person aged 18 or over who has been convicted of a relevant offence. The domestic abuse protection order will only be issued where the court considers that on the balance of probabilities there is a risk of further abuse and it is necessary to protect the victim. The court is required to also consider the well-being of any children involved and any views from the suspect, the victim, or the householder. Part 3 also contains the governance arrangements around these orders, including the right of appeal and the right to apply to vary or revoke such an order. The law also gives the court the power to impose notification requirements on people convicted of domestic abuse or similar offences. This is intended as a mechanism for risk prevention, following the same structure as the sex offenders law, and the court may order such a person to provide police with relevant details or any relevant changes for a specified time. I should note as well, sir, that the domestic abuse law has been fully reviewed for ECHR compliance. Although I think that the note in the report says no human rights issues arise, I think this downplays the detailed and comprehensive analysis of the human rights issues engaged, which was carried out by the Law Officers Department at the time, and which found the law to be compatible. Sir, domestic abuse is deeply damaging, invidious behaviour, and we know that it causes much harm in our community. The previous Assembly acknowledged that when they voted in favour of this draft domestic abuse law over a year ago. I can only apologise to members, but more importantly to victims, that it has taken some time to bring this law into force. The delay was not expected, and I and my team have done our best to get things back on track. I'm grateful to all those who've worked hard on the law and to prepare to bring it into force. This is a very important piece of legislation which will significantly improve the protection available to victims of these horrible offences. I ask for the Assembly's support in bringing this law into force.
Very much, Minister. Is the proposition seconded?
Seconded, sir.
Does any member wish to speak on the proposition? Deputy Tadier.
Thank you, sir. I note that the Minister did address that there was a delay, and I was thinking of asking a question, and now that she's mentioned it, I thought I would ask for clarification on that point. So we know that the previous Assembly adopted the law on the 28th of April last year, and that it was sanctioned by the Privy Council on the 19th of July that year, and then it was registered in the Royal Court on the 5th of August last year. So I think there is still about 10 months or so, 9 or 10 months. Can I just ask why there were delays, and if there's something that we should know about? Does the department need more resources, or was there a technical issue or issues that can explain this delay?
Deputy Catherine Curtis.
Thank you, sir. I just want to say that the Children Education and Home Affairs Scrutiny Panel supports this law being brought into force as a priority. It was approved by the States Assembly in April 22, scrutinised by the previous scrutiny panel, and the current panel has questioned the Minister at length. It seems it's ready to go and very much needed.
Does any other member wish to speak? Deputy Ward.
Extremely brief, sir. It was the previous panel that scrutinised and gave it full support, and this is a much needed change to our laws. Thank you, sir.
Does any other member wish to speak on the proposition? If no other member wishes to speak, then I close the debate and call upon the Minister to respond.
Thank you, sir. And I thank members for their contributions and their support. In answer to Deputy Tadier's question, the delay in bringing this legislation is regrettable. The Assembly was previously advised in response to an oral question 24 of 23 that the law required rules of court to be prepared and in place prior to implementation, and that this was the source of the delay. Such rules are developed by the Law Officers Department and made by the Criminal Procedure Rules Committee. However, further to my liaison with the law officers and the judiciary, officers were advised that the courts would be able to manage procedures so that the law can be brought into force ahead of rules being in place. Sir, on that basis, I maintain the proposition.
Do you call for the appel?
Yes.
As called for, I invite members to return to their seats. The vote is on the adoption of P23, the Appointed Day Act for the Draft Domestic Abuse Jersey Law. I ask the greffier to open the voting and members to vote. Members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. The regulations have been adopted. I beg your pardon. The Appointed Day Act has been adopted. 41 votes pour, no votes contre, no abstention. I beg your pardon, 42 votes pour. There was one in the chat who has voted. Very well. The next item of public business is the draft Social Security Amendment of Law Number 18, Jersey Regulations, P24, lodged by the Minister for Social Security. The main respondent is the Chair of the Health and Social Security Scrutiny Panel. I ask the greffier to read the citation.
Draft Social Security Amendment of Law Number 18, Jersey Regulations 2000. The states make these regulations under Articles 50 and 51 of the Social Security Jersey Law 1974.
Minister.
Thank you, sir. I would like to propose the Draft Social Security Amendment of Law Number 18, Jersey Regulations. I'm bringing these regulations to the States to clarify some specific references in the Social Security Jersey Law 1974. Under Articles 50 and 51 of that law, the Social Security Minister has the power to amend the law by regulations. The two regulations clarify different aspects of the law, so I will speak to each regulation in course and will ask for separate votes. That said, I hope that members will agree that both regulations are simple and represent sensible housekeeping changes. Regulation 2 aligns the calculation of contribution factors in the law with the original policy intention and current operational practice. If we don't do this, we will need to reconsider the current approach to these calculations, which could lead to additional costs to the Social Security Fund. Regulation 3 separately amends that part of the law that prevents a person from doing any work when they're in receipt of short-term incapacity allowance. This will make it possible to make a change by order that will give Jersey workers the option, as they would in other places, of doing limited or adjusted duties in the workplace whilst they're recovering from an illness. Although the majority of changes will be accomplished through that order, I will explain how this will work. And I do that because I want members to be assured that any changes will be sensible and beneficial. In particular, I would emphasise again that the changes absolutely do not change or remove a person's entitlement to sickness benefit. They do not introduce new conditions to obtaining the benefit or force people to do anything new in order to receive it. As confirmed yesterday, there is no sanction regime associated with this change. I very much welcome the supportive comment lodged by our scrutiny panel, who have taken the time to consider both regulations in detail and make helpful observations about the impact of these changes. I welcome their engagement with the reasons behind these changes and will go into further detail about how I propose to meet their recommendation. Turning first to Regulation 2. This regulation, if passed, will amend Article 8A in the Social Security Jersey Law 1974 to provide that the rounding of the contribution factor will be according to the usual rules on rounding and not always rounded up. A contribution factor measures how much of a contribution record an individual has over a period of time. This determines their eligibility for and the value of any contributory benefits or social security pension due to that person. In the last step of calculating contribution factors, they are, in practice, rounded up or down to the nearest third decimal place according to the normal rules of rounding applied in many financial calculations. The law currently requires all calculations to be rounded up. However, this was not the intention when Article 8A was added into the Social Security Law in 2012 as part of a list of minor housekeeping changes alongside the main changes required in the law at that time. If the Assembly approves this regulation, no one will be made better or worse off because the law will be aligned with how we have always carried out these calculations. If the Assembly doesn't approve the regulation, then I will need to consider the reasons for this and what further legal or operational changes may be required. This might require providing slightly larger pensions by 24 pence per week, which is roughly £13 a year, and if so, this would cost the fund eventually an extra £200,000 to £300,000 per year, with the expected increase in the number of pensioners in the future. It would also create an issue regarding some of the contribution factors we have calculated and rounded down. Again, we're talking about 24 pence a week since the law was changed in 2012. This will be difficult to resolve in a manner that is cost-effective to both contributors and pensioners generally. Turning now to Regulation 3. If passed, Regulation 3 will allow a person to claim short-term incapacity allowance on a day if it is prescribed as a day of incapacity by the Minister. This will ultimately remove the prohibition on a person claiming short-term incapacity allowance on a day on which they work. At present, a day of incapacity is currently defined as one in which no work can be done at all. Article 15 of the law includes a provision that a person is not entitled to short-term incapacity allowance or STIA, or more commonly, being signed off work sick, for any day on which he or she works. This includes voluntary and even therapeutic work, and means when someone is ill, they are obliged to remain at home, not working or volunteering or doing anything that may actually improve their health condition. Regulation 15, this regulation removes this prohibition without any further change to Article 15. As we discussed yesterday, removing this provision alone will not affect claims to short-term incapacity allowance because the current wording of the Social Security Incapacity Benefits Jersey Order 2004 contains a very similar provision as set out in the report to the proposition. If these regulations are passed, I intend to go on to amend that order to allow that a day may also be a day of incapacity, and thus a person may claim short-term incapacity allowance if a person does some work, but only under specific conditions. This is how comparable benefits work in other places, such as the UK and Guernsey, and represents an essential modernisation of Jersey's system. It will have benefits to workers, their employers, and Jersey's economy. I intend to make changes by order that only allow a person to do some work if it is agreed that it will support their recovery from illness or management of a health condition. This will be part of an approved return to work plan. In order to qualify under the short-term incapacity rules, this plan will be agreed between the worker and their employer and, where appropriate, with input from relevant medical professionals responsible for their care. It will be designed to reflect modern medical understanding that work or work-related activity can benefit recovery and management of some health conditions, and it will be agreed by a specially trained officer in custom and local services. If these conditions are met, the worker will be able to do some work while also receiving short-term incapacity benefit. They will remain fully protected by the benefit and can return to complete absence from work if the return to work plan isn't successful. There will be no penalty to any person who decides that this type of return to work is not right for them. There is no question of a person being forced back to work when they are not well enough to return. This is the first stage of a major overhaul of benefits and a key part of my ministerial agenda. Jersey faces significant challenges in skills, job vacancies, and the difficulties that workers and their employers have in managing some long-term health conditions, in particular mental health and musculoskeletal problems. Our current system makes it harder for people to manage these common health conditions and others. Some of them are conditions that shouldn't necessitate total absence from activity. This is causing some people to leave work permanently, and I believe we have to offer more help. While there is evidence that amended or adjusted duties could help the person recover from their illness and could help them manage it across their working life, there is no sense in our benefit system enforcing total absence from the workplace. Sir, I'm conscious that the speech is quite long, so I'm going to shorten it a little unless people have any questions, or would you like me to?
It's entirely a matter, if you're satisfied you've dealt with the principles, so that there'll obviously be the opportunity for anyone to ask you questions in connection with the specific regulations when you get to second reading.
Yeah, and I'm conscious that members will hear more about the new scheme in due course. So I'll continue. The scrutiny panel have also asked that we work to expand the referral process to other healthcare professionals. I'm happy for that to be something that we explore throughout the launch period of this new service. Scrutiny have also asked me to communicate the scheme very carefully so that workers, employers and healthcare professionals are all aware that they have a role to play in this new system. I absolutely agree with that and have asked officers to ensure that this recommendation is met. I would like to thank our scrutiny panel for their constructive engagement on this topic. I'm sure you will appreciate that the detail of this new service is a lot to cover, and it relates to small change, although it relates to small change to our legislation. I'm pleased to offer all members a briefing with our specialist medical advisor and the policy officer leading the project, and I believe that invitations for a briefing in the near future have already been issued. My officers and our advisor will be able to explain all the ways in which this new system will help Jersey workers and our economy. These regulations come into force 7 days after they're made. At that point, I will make the order that enables the new scheme. I'm aiming for the new service to be operational this year. I would like to propose these regulations, sir. Thank you.
Are the principles seconded?
Yes, sir.
Does any member wish to speak on the principles? Deputy Ward.
Thank you, sir. Just briefly on behalf of the panel, I won't go on forever because I know that every member of this assembly would have read the comments paper, the wonderful 5 pages of prose, and I'd like to publicly thank the officers who behind the scenes work on these comments papers to produce a coherent set of information, often with some very complex things going on in the background and quite a significant workload. So I'd like to thank the members of the GREF staff who do that. So just a few things on Regulation 2. I'm not even going to try to detail it. I do recommend you read parts of the comments because it does sum it up very well, the changes, but the panel did not have a significant problem with that at all. It was something that should have been done many years ago, we believe. In terms of Regulation 3, there were some key points. The intention is to, and I think the intentions of this, and this is why I speak in the principles of this area, was to improve recovery, mental health, and give control over the circumstances by the individual who is off sick. That's a very important part of recovery, and I think that if this system works well, that can be a very significant positive outcome. And it is very important that all parties have agreed and that people are not forced back to work. And we're very pleased to hear the Minister say exactly that on the public record, and we would certainly keep a watch for that, because that is not the intention of this. And it's very important that the employee themselves has control over that return to work. There is also a couple of extra things. Support for businesses in navigating through the new rules is very important. And the communication that comes with this change is going to be vital. Particularly as people need to know what it actually means and to get the nuances of that not forcing people back to work. I think that's going to be a very important part of the work done by the department itself. Finally, the notion that phased return to work may be agreed by others other than GPs, I think is something that is going to happen with our changing healthcare systems and the increased role of things like physios, for example, and the return to work. And the panel had no problem with that. But we do need to keep, again, the classic phrase for a scrutiny panel, a watching brief over what's going on in those circumstances to ensure that it actually works. And also the phased approach to a range of conditions. I think it's very important to make clear that not every condition is included at the beginning of this process. And I think that phased approach is sensible so that it works, and the information about how the system will work for employees and employers is very important as we move into the future. So on behalf of the panel, I think I can pretty much say that we are unified in saying that we do approve this and would recommend these regulations. Thank you, sir.
Deputy Dublé.
Thank you, sir. I just wanted to ask the Minister for clarification on a phrase that she used, which she mentioned that those who are claiming incapacity benefit should stay at home and not work. And I just wanted to clarify that, because actually it's something that has been raised with constituents in the past, whereby they have been signed off work and their workplace have told them that they must stay in their house, yet their GP is saying to them, actually it's important that you get out for fresh air, it's important that you go and meet with people so that you're not becoming lonely. And indeed, I'm aware of a pilot, I'm not sure actually what happened with the pilot or whether it was continued, of social prescribing, which I think happens a lot in the NHS more and more often, where the kind of emotional and social aspects of well-being are being learnt about by GPs and taken into account when they're prescribing and recommending treatment. So I just wanted the Minister, I'm sure she will reassure islanders that, you know, if they are unwell and their GP has recommended that they get fresh air or spend time with loved ones, and that's important for their recovery, that they are permitted to do that whilst claiming that benefit.
Very much, Deputies. Any other members to speak? Deputy Mezek.
Thank you, sir. Whenever I see changes proposed to the benefits system, I get very nervous, and I do so because the rules are littered, unfortunately, with some very silly rules from time to time, rules that I've come up against in my constituency casework, where totally illogical and unnecessary hardship is often visited upon claimants because of rules that just don't work in practice or don't take into account people's individual circumstances. So when I see something like this lodged, I'm very keen to give it a look and see whether it's going to make things better or worse for vulnerable people. And I do that in the context of the changes which were made to long-term incapacity allowance in 2015, which I regarded as being cruel and caused hardship to many constituents who I had to support down at the Social Security Department, and which I never want to see a repeat of. Having listened to what the Social Security Minister has said and what is written in the report, I think what she's proposing makes a great deal of sense, and she's provided a very helpful reassurance in her words on that, where there may well be plenty of cases where there are people who are claiming short-term incapacity allowance, where it would be good for them and the community for them to be assisted back into work without having to face any kind of sanctions or anything if they attempted to do that. And we can't construct a system to support them through that whilst this prohibition of them working remains in the law. So the Social Security Minister's drive to remove it from the law makes perfect sense, and then that gives her the flexibility to come up with a scheme that will help those people. I think the reassurance that she's given in her words about the intentions behind that to not resemble some of the schemes that have been tried in the UK that have been based on coercion and that have been based on sanction, rather than looking at people's individual needs and finding out what is best for them and supporting them through that. That's fundamental. So I speak only to reiterate our request to her to just be absolutely clear as that work goes on, so we can have confidence that it does everything that it sets out to do, and we can be confident that there won't be situations where people who are ill inadvertently face hardship because of rules not being appropriately tailored to their circumstances. But what's proposed in these regulations today makes perfect sense, and as things stand, I'm fairly confident that it's helping us move in a positive direction there, so I'm happy to support them.
Very much. Deputy Ferry.
Thank you, sir. Like the Minister, I urge members to support these regulations. I would like to speak in particular to Regulation 3, which helps modernise our sickness benefit system. This is a system which most of us will use at some point in our lives, but it hasn't evolved to keep pace with working life as it is in the modern age. I have a personal interest in this because, as well as the understanding that I have gained through working with disability groups and within the third sector, I hope that members will forgive me for drawing on an anecdote from much earlier in my career. My first role at the Social Security Department was that of a visiting officer, and I would regularly encounter people who would quite happily have done some work, but were prevented from doing so by our benefit rules. Although this has been some time ago, it is a sad fact that Jersey's benefit system are very much rooted in an earlier age. I think we have a great opportunity here to help to change this. The awareness that doing some work would be helpful is counter to the image that perhaps some people might have about benefit claimants, or even about people who are signed off from work. Most people like to be active. Even when they aren't at their best, they prefer to reduce activity rather than to stop doing everything. This is definitely the case for certain types of illness that affect more and more people in their working life. I'm talking about mental health and back pain. People may not be able to cope with a full working week, but that doesn't mean that they need a week in bed. These ailments are all growing, but our current system isn't doing enough to help. It is good to rest when you need to, but in lots of cases, people miss the routine of work and worry about the jump from being totally signed off to being back into full-time work and assuming their full duties. They stop being physically active, and under our current rules, they can't even take up voluntary or therapeutic work. We know that lots of conditions and a gradual return is going to benefit people. This is what the health advice says, and that's what these changes will allow people to do. I say allow because it will be optional. We want to give people a service that they can choose to take up. We want them to support them and understand what will work in their own particular bespoke case, and to come to an agreement with their employer. We want to support employers too, to help them to understand how these changes can benefit them, all in a time when employers finding suitable employees is becoming increasingly difficult. I think this is a really positive step, and I'm glad to see that our scrutiny panel feel the same way. I would urge all members to support these proposals, sir.
Very much, Deputy. Does any other member wish to speak on the principles? No other member wishes to speak. Then I close the debate and call upon the Minister to respond.
Thank you, sir. I'd like to start by thanking everyone who's spoken, and in particular for their, I think, generally supportive comments on these regulations. If I could just touch on one or 2 points, please. Deputy Ward mentioned support for employers, and that will very much be part of this scheme. I know from having been a manager how that it can cause employers some anxiety if you have an employer who's been off for, an employee who's been off for weeks or months, particularly with things like mental health conditions, and they want to return to work on a phased basis. That can cause concern as to how you get that person back into the workplace safely and in a way which promotes the recovery and doesn't make them more unwell than they have already been. So we will certainly be supporting employers through this process and helping them with getting their employees back into work. Deputy Dubley, thank you for that. That's a very strict interpretation of the rules. I think the rules don't say or shouldn't be interpreted as meaning that a person must stay at home. Because again, I know as a manager, often people, if they do have mental health or muscular conditions, that their GP will be saying to them, get out in the fresh air, go for a run, go to the gym, because these are all things that will help your recovery. And our current rules should not stop people doing that, but it does stop them, for example, volunteering in the charity shop or a charity cafe or doing any work. Yes, it should also help with concepts like social prescribing, and that it lets people have a much more normal life during their period of ill health. And Deputy Mesek, yes, I agree, nobody hates a silly rule more than me. I'm confident that this scheme will make things better for employees and employers, and I assure him that we will monitor the scheme closely to make sure that there are no negative or unintended effects. So I thank members for the comments, and I ask members to support the proposition. Sir, I maintain the principles and call for the appel, please.
As called for, invite members to return to their seats. The vote is on the principle for P24. And I ask the referee to open the voting. If members have had the opportunity of casting their votes, then I ask the greffier to close the voting. The principles have been adopted. 44 votes for, no votes contra, no abstentions. I take it, Deputy Ward, from your previous intervention, the scrutiny panel doesn't wish to call the matter in?
No, sir.
Indeed. Then how do you wish to deal with the matter in second reading, Minister? You've obviously already explained the regulations.
Yes, sir, I think I did say I would propose the regulations individually because they are different, but if members were happy to take them on block, I'd be happy to propose on block. I think given they're generally supportive, if we could propose on block, please.
Very well. Are they seconded in second reading?
Yes, sir.
Does any member wish to speak on the regulations in second reading? No member wishes to speak. I close the debate. Those in favour of adopting the regulations in second reading kindly show. Those against? Regulations are adopted in second reading. Do you propose in third reading?
Yes, sir.
Well, are they seconded for third reading?
Yes, sir.
Does any member wish to speak in third reading? Those in favour of adopting the regulations in third reading kindly show. Those against? The regulations are adopted. Very well. The next item of public business is the draft limited partnerships continuance Jersey regulations, P25, lodged by the Chief Minister. The main respondent is the Chair of the Corporate Services Scrutiny Panel, and I ask the Referee to read the citation.
Draft Limited Partnerships Continuance Jersey Regulations 2000. The states make these regulations under the Order in Council dated 28th of March 1771 and the Order in Council dated 14th of April 1884.
Chief Minister.
Sir, Deputy Miller will be the rapporteur for this item.
Deputy.
Thank you, sir. Thank you, Chief Minister. Sir, I propose the draft Limited Partnerships Continuance Jersey Regulations, otherwise the regulations during this speech. I'm going to go off speech for a moment just to say that these regulations, to a significant degree, reflect a law that has been in place since the early 2000s and allow companies to continue. Those continuous regulations have been well used in the corporate sphere, and I would just like to make the comment that I've always hated the word continuance, and it would be much easier if we used redomiciliation, because that is actually what we're talking about. But anyway, that's just a personal bugbear. These regulations are a priority piece of financial services regulation, which are intended to renew the existing limited partnerships continuance Jersey regulations passed previously by the states as triennial regulations in 2020, and which are due to expire on 17th of July 2023. The regulations fulfil two key policy objectives. They will allow foreign unincorporated limited partnerships wishing to exit their existing jurisdiction of registration and migrate to Jersey, so basically redomicile from their current place of their current seat into Jersey. And secondly, to ensure our legislative framework continues to offer an attractive and competitive legal framework within which our international funds business can operate. The regulations play an important role in ensuring Jersey remains competitive with other financial services centres which specialise in funds business. The Jersey Limited Partnership is the preferred legal structure for fund managers and promoters to use for international funds managed from Jersey. Our fund sector is a core pillar of our financial services industry and a key area of growth, with over £488 billion of global assets under management. Jersey is recognised internationally as a jurisdiction of choice for alternative fund business, primarily private equity. The regulations permit Jersey to capture opportunities where funds wish to exit from another jurisdiction and to relocate their operations and redomicile the fund to Jersey. This may be because of, for example, the European listing process, or for some other reputational, political or business reasons. The regulations create a statutory process by which a foreign limited partnership can continue and be registered as a Jersey Limited Partnership and be afforded the protections and benefits provided by our limited partnership law. This statutory process reflects equivalent continuance provisions in competitor jurisdictions' laws. The regulations supplement our existing limited partnership law and the Control of Borrowing Order. They were originally passed as triennial regulations due to the urgency and technical restrictions in amending the limited partnership law in 2020. Since that date, the limited partnership law has been updated, with the amended law coming into force in July last year. However, within the timescale and resourcing constraints as a consequence of our Moneyval assessment this year, it has not been possible, regrettably, to bring them into permanent law. The decision to renew the current regulations is also partly due to industry's own desire to extend the original regulations to include continuance out, as well as continuance in provisions, which would require further resource and time. And what I mean there is just simple reciprocity, which allows a Jersey Limited Partnership to redomicile to another jurisdiction should it so wish. The original regulations passed by the States Assembly in 2020 were substantively in the same form as the regulations before you. They have been updated to account for changes to limited partnership law since they were passed, and to modernise the drafting in line with current drafting standards. The financial services industry supports the renewal of the regulations and the revisions made to the original regulations. The draft regulations were shared with and worked on together with industry and approved in their final form. Furthermore, Government, before deciding to renew the original regulations, has sought the feedback of industry, the registry and the Financial Services Commission supervisory team on their experience and use of the original continuance regulations. Industry has confirmed that they have enhanced Jersey's fund offer and that there has been business arising from their introduction. The registry and GFSC supervision team confirmed that their experience of the original regulations had not raised any concerns and they did not object to the renewal. It's a ministerial priority for the regulations to be incorporated into permanent law once the current constraints no longer apply, and officers will be working on doing that from next year. If I could summarise briefly how the regulations supplement and add to the Limited Partnership Jersey law as amended and associated law. They introduce the concept of an eligible foreign limited partnership. This is a foreign limited partnership which qualifies for continuance under the regulations. This requires it to be solvent, not in a state of being wound up in administration or deregistered in its home jurisdiction, and to be legally entitled to migrate out to another jurisdiction under its own laws. The regulations introduce an application process for eligible foreign limited partnerships to continue as a limited partnership under Jersey law. There are certain documents and statements which need to be filed before an application for continuance can be approved by the registry and a certificate of continuance issued. This includes an application for limited partnership to be registered as a limited partnership under our law and for an application for consent to be made under the Control of Borrowing Order. This is to ensure that proper disclosure has been made of its beneficial ownership and to enable it to qualify, if required, as a Jersey private fund. The regulations set out the way the FSC will determine any application for continuance and the basis on which appeals can be made by an applicant if an application is rejected. The Financial Services Commission is expressly given a mandate to reject an application on the grounds of it being contrary to public interest. The regulations also require that before any application for continuance can be made, that an application for consent under the Control of Borrowing Order is granted and a consent issued. The registration of the eligible foreign limited partnership as a limited partnership in Jersey and the issuance of a certificate of continuance is made simultaneously. A certificate of continuance confirms that the eligible foreign limited partnership is from the date of the certificate continued as a limited partnership within Jersey and that it has complied with requirements of the regulation. This will give it proper standing in other jurisdictions as a Jersey limited partnership. The regulation also set out the statutory effect of continuance. This provides certainty that it remains the same limited partnership that previously existed under the foreign jurisdiction's laws. This is important for tax reasons and to also give certainty as to the ownership of its assets, the validity of the contracts it has entered into, and its liability to third parties for its acts and omissions before its migration out. The regulations give the FSC power to charge fees and publish forms and other documents for the continuance application, and it introduces an offence for any person who provides or helps to provide false or misleading information to the Financial Services Commission in relation to the application. The maximum penalty mirrors the equivalent provision under the Limited Partnership Law. It provides that the regulations will expire on 17th July 2026, the third anniversary of their commencement. So the regulations will allow Jersey to maintain its competitiveness for funds business and keep it aligned to our competitor jurisdictions' laws. Sir, I propose principles. Thank you.
Are the principles seconded? Does any member wish to speak on the principles? No member wishes to speak on the principles. Those in favour of adopting the principles kindly show. Those against? The principles are adopted. Does the scrutiny panel wish to call this matter in? Before we move on to second reading, Deputy Miles, I think guilty as charged. Thank you very much indeed. And the Greffier welcomes the contribution to the Fighting Fund. Thank you very much indeed. How do you wish to deal with the matter in second reading, Minister?
Sir, may I propose the regulations en bloc?
I'm sure you can, yes.
Yes, sir.
They seconded. Does any member wish to speak on the regulations in second reading? Those in favour of adopting in second reading, kindly show. Those against? The regulations are adopted in second reading. Do you propose in third reading?
Yes, sir, I propose the regulations in third reading.
Are they seconded for third reading? Any member wish to speak in third reading? No member wishes to speak in third reading. Those in favour of adopting in third reading, kindly
We
show.
have the appel, please, sir.
The appel is called for. I invite members to return to their seats. The vote is on the adoption in third reading of P25, the Draft Limited Partnerships Continuance Jersey Regulations. And ask the Greffier to open the voting. Members to vote. Members have had the opportunity of casting their votes. Then I ask the Greffier to close the voting. The regulations have been adopted in third reading, 43 votes pour, no votes contre, no abstentions. The next item of public business is the Jersey Overseas Aid reappointment of Commissioner P26, lodged by the Minister for International Development. The main respondent is the Chair of the Economic and International Affairs Scrutiny Panel. I ask the Greffier to read the proposition.
The States are asked to decide whether they are of opinion to appoint Mr Douglas Melville as a non-States Commissioner for a further period of 3 years in accordance with Clause 7.4 of the Constitution of the Jersey Overseas Aid Commission as set out in Schedule 1 to the Jersey Overseas Aid Commission Jersey Law 2005.
Minister.
Thank you, sir. It gives me great pleasure to propose Mr Douglas Melville as Commissioner of Jersey Overseas Aid. For those of you who don't know Mr Melville, his day job is the Financial Services Ombudsman for the Channel Islands, where he brings an extremely valuable skill set to Jersey Overseas Aid, combined with a great deal of development aid experience. So I believe we're extremely lucky to have him on board. Mr Melville has served as a non-States Commissioner since 2015, and since 2018 has served as Vice Chair of the Commission. He will be joined by 2 other non-States Commissioners, all of whom give their time in an honorary capacity. I make the proposition, sir.
Is the proposition seconded?
Yes, sir.
Does any member wish to speak on the proposition?
Thank you, sir. I hope this is relevant. I'm sure you'll tell me if it isn't. I just wanted to use this opportunity to congratulate the Jersey Overseas Aid personnel for the tremendous work they're doing with the current crises that are facing the world, not only the situation in Sudan, but the ongoing crisis in Ukraine resulting from the invasion by Russia more than a year ago. I want to pay particular tribute to the Overseas Aid Commission for making sure that substantial funding is going to Ukraine, and now in particular following the twinning of St. Helier and Mykolaiv, that funding is going into that part of the country and doing tremendous good. And so it gives me great pleasure to support the proposition. Thank you, sir.
Thank you very much, Conatable. Does any other member wish to speak on the proposition? No other member wishes to speak? Then I close the debate and call upon the Minister to respond.
Thank you, sir, and I thank the Constable for his very kind remarks. They are extremely relevant, and I'm always grateful for my excellent team that supports the endeavours of Jersey Overseas Aid. With regard to the funding for Ukraine, I think it wasn't only our own funding, but indeed yours, sir, through the appeal to the people of Jersey who gave very generously. Thank you, sir.
Thank you very much. Those in favour of adopting the proposition kindly show.
Help, sir.
That is called for. I invite members to return to their seats. The vote is on P26, the reappointment of a commissioner for the Jersey Overseas Aid Commission. I ask the greffier to open the voting and members to vote. Members have had the opportunity of casting their votes. And I ask the greffier to close the voting. The proposition has been adopted. 37 votes for, no votes against, and no abstentions. Very well. We now come to the draft FB Playing Fields Jersey Law, P27, lodged by the Minister for Infrastructure. The main respondent is the Chair of the Environment, Housing and Infrastructure Scrutiny Panel. I ask the greffier to read the citation.
Draft FB Playing Fields Jersey Law 2000, a law to permit the construction and use of buildings and other infrastructure on the FB playing fields for the purposes of sport and recreation and for connected purposes. The State, subject to the sanction of His Most Excellent Majesty and Council, have adopted the following law.
Minister.
So, with your permission, I'd like to pass this over to Deputy Stevenson, who's the Assistant Minister.
Certainly, Assistant Minister. So,
Yes, sir. I just wanted to register a declaration of interest because my property actually adjoins FB Fields. So, if I do speak, I just wanted to raise that, sir.
Thank you very much indeed.
Thank you.
Deputy Stevens.
Thank you, sir, and also I'm grateful to the Infrastructure Minister for the opportunity to present this to the Assembly today. I want to start by recognising the important role that FB Fields has played for Jersey's sporting community over many decades and continues to do so. From school sports days to elite level competition, its track and fields have seen it all. And only a couple of weeks ago, I was reminded of just how wonderful a facility it is when Jersey played host to the ICC World Cup European Division 2 Women's Cricket Tournament. The visiting teams were hugely complimentary of the facilities, and I heard a particularly lovely story about the Turkish team, who I was told don't often actually get to play on grass, let alone a surface as well looked after as the one at FB. And that was a really timely reminder, actually, to all of us in Jersey about the facilities that we do have. So today, as well as cricket, FB Fields is used for athletics, school sports days, winter football. It's got cricket nets, a table tennis centre, multiple pavilions and changing rooms, 2 small parking areas, a very dated grounds maintenance shed, a recycling area and some rented office space. It's home to clubs like Jersey Spartans, the Jersey Table Tennis Association, and also to our own Jersey Sport. This is a well-used and well-loved facility at the heart of our community. But we know that it could be even better, particularly when you consider the densely populated areas of housing on its edges. It has huge potential, and it can play a vital part in the extension of the Eastern Cycle network. We also recognise that parts of FB are ageing. We need to act now to plan for its future and to enable the long-term effective use of this treasured part of the sports facilities portfolio. There are also some challenges that we need to address, including lease issues owing to the restrictive covenants currently in place, ageing changing rooms, facilities for our groundskeepers which need improvement, and cricket ball strikes into nearby properties, to name just a few. In order to continue to develop sport use on the site and improve the use of FB Fields for the community to access and utilise for recreational purposes, the current covenants on the site need changing, which is why I'm presenting this proposition to members today. And earlier this week, I emailed members 2 images to provide some context for today's debate. The first shows FB Fields from above and clearly shows how the facility sits at the heart of this part of St Clement.
and the housing I mentioned earlier around it. FB Fields is an important green lung in the east and in an area which has seen much development in recent years. The second image is a map which hopefully makes it clear the areas that we're talking about today. And for clarity, this proposition relates to the blue and green areas on that map. And that's, for anyone who hasn't got the map in front of them or listening to this debate, that's the athletics track and its surrounding areas, and then the playing fields. It does not relate to the old netball courts behind the pavilion, which are subject to a separate covenant. And a vote in favour of this proposition today will not impact on that covenant that applies to that highly protected square of land, which is known as the Normandy Gift. Nor are there any plans to seek to change it in future. And that's really an important point, and I know that one that members are really keen was put on record, not just in assurance alongside those maps. So by way of a very quick history lesson, the grounds at FB Fields are named after benefactor Florence Boot, who was the Jersey-born wife of Jesse Boot, the first Baron Trent. The two areas we're talking about today, known collectively as FB Fields, were gifted as sporting land to the public in 1951 and 1953. In 1983, the Education Committee received a report which concluded, if the athletics potential of Jersey's youngsters is to be reached, the number one priority is a decent track and facilities with it. As a result, a 6-lane, all-weather 400-metre track was built in 1987 and a clubhouse was added in 1999. Whilst it was resurfaced in 2015, the athletics track is now 36 years old. Before this, all-weather netball courts had been constructed and the Normandy Pavilion was built to accommodate players' needs. The Jeff Reed Table Tennis Centre was opened in 1999, following a donation from Mr. Reed and a grant from the Sport and Leisure Committee. Both of the green and blue areas on the map, the track and the fields, are subject to an identically worded restriction set out in the relevant deeds of gift, which state that the areas concerned must be kept and maintained as a sports ground or playing fields to be known as FB Fields for the benefit of the public of the island. Those covenants limit both the current use of the site and any future potential proposals for its redevelopment as a centre for the provision of sport and community recreation. As it stands, two of the buildings which I've mentioned just now on the site contravene those existing covenants, which would need to be amended to allow them to remain. This situation has persisted for a considerable period of time without challenge from the direct beneficiaries of the covenants or the public, and it's not anticipated that any challenge is likely. Nevertheless, the situation should be regularised to ensure alignment between the covenants and the situation on the ground. The covenants also prevent any future development of the site. And at this point, I want to make it really very clear that when I say development, I mean development which absolutely respects the intention of the original covenant to provide sporting land to the public of Jersey. And I'll draw members' attention to Article 4 of the proposed new law, which provides for the continued preservation of the historical condition that FB Fields is a terrain de sports, a playing fields. And of course, normal planning processes and prior to that extensive public engagement and consultation on future use would still be required. For these reasons, we do not know exactly what a future FB Fields will look like or at this stage when improvements could be made. What we do know is there is huge potential. Possibilities include completing the Eastern Cycle network, creating an inspiring active place supporting a populated catchment area, including a densely populated area of social housing right next door where many homes do not have their own outside space. It has the potential to offer space for young people and families to spend time and play, better facilities for athletics to grow and develop, and for our athletes to compete. We can resolve issues on the existing site regarding the buildings there already, sort out the lease issue with the current athletics clubhouse. We can work to negate the cricket ball strike issues and provide fit-for-purpose facilities for our ground staff to work in. Approving this proposition today unlocks the potential to seriously start considering these opportunities, and it does so in a way which respects the gift made by the Boot family all those years ago. As a final point, and one which I think is incredibly important, contact has been made with representatives of the Boot family with the closest connection to the island, and officers have discussed this all with them. We have their support for this move in writing, and I just want to thank them for that, but also more widely for all that their family have done for our island over many years. In closing, here's a quote from their correspondence. I'm grateful to have been extended the courtesy of your approach, and I confirm that, provided the use of any new buildings relates to the original use for which my great-grandmother gave the land, then we fully support any changes to the law to vary the original grant. With best wishes. Thank you, sir.
And you presumably move the principles?
I do, sir, sorry.
Not at all. Are the principles seconded? Does any member wish to speak on the principles? Deputy Rob Ward.
Thank you, sir. I've been looking at this, and I just have some questions, really. Obviously, there's, it makes sense to do it. There are just some things that ring a few alarm bells in my mind, which are the facility to build buildings, and the phrase was, we can seriously start considering, which is a long way away from what we might be voting for as to what the practicality, sir, is of what this might be. And whenever we start to talk about buildings in playing fields, there are questions that arise to me are, what will the nature of those buildings be? Who will have control over those buildings? There is an ethos, sir, I believe, in governments, free market governments, of privatisation, of bringing in the private sector and allowing them to build on land for a minimal price for the land, or access to the land, or lease for the land. And then we lose control of that land inadvertently, or by the back door, or over a time, because the nature of the beast that is there, if I put it that way, sir, of the building itself, it changes in terms of its use, its ownership, and who has control over that use and the nature of that use. And that concerns me greatly when we have such a small island with such a small number of spaces and facilities for people, particularly on the east of the island. I used to work over there and travel over there every day. And they are essential for the schools in the area, for the increasing number of buildings in the area as well. And we have that I think it's the wrong phrase to say urban sprawl, but we do have that urbanisation of those areas, so we have to be extremely careful. We do have to be careful regards the Eastern Cycle Path, because one of the reasons the Eastern Cycle Path doesn't exist because it wasn't planned out from the beginning when buildings went up. And those spaces just simply don't exist anymore. And now I believe that it is a pipe dream to have the Eastern Cycle Pathway in the way that there are things out west from St Brellard's outwards. You're going to have to look for some alternatives in terms of road use and so on, which doesn't seem to be something that's being done at all. And so therefore I do have concerns, and they are genuine questions about the future, because we can agree this, but there is a long way to go in terms of what this will end up with FB fields being used for. So that's the main concerns I have, sir, that I'd like to raise. And some reassurance, this isn't simply, sir, going to be used to encourage private tender. Also, sir, I will say that I think there are some issues that we do need to come back to in this Assembly and beyond, with arm's length organisations and sport on this island, and what the drivers are behind what they're doing, sir. Because we have a very fragmented sports provision on this island. We have lots and lots of different organisations, all really working hard to do their best, and they mean well for all sports. I'm not going to start, because as soon as you name a sport, you leave one out and you get in trouble. But there's lots of them. And I'm very aware, sir, that what we may end up with is a facilities that is yet another arm's length organisation with different drivers, profit motives, having to sell their services, as we've seen with Jersey Sport in schools, for example, selling services from one government-owned organisation to another. And it changes the nature of access to those facilities in the long term. And I would like some reassurance that that is not going to happen as we come to the principles of this debate. Thank you, sir.
Deputy Lewis.
Thank you, sir, and I thank the Assistant Minister for bringing this to the Assembly. One of the overhead photo that she referred to shows the FB Fields for what it is. It's a fantastic green lung, a wonderful open space to be enjoyed by everyone, but most especially those who live in the area. And I, sir, was one who lived very, very close to the FB Fields when I grew up. And in the 1960s, I enjoyed using the facilities both as a schoolboy and out of school at weekends, and it was certainly somewhere that we all aspired to go to, a wonderful open space. I can see why the Assistant Minister wants to change restrictions. I'm sure we all can. But in other ways, sir, I'm a little bit surprised why she would want to bring this dilution of the restrictions on what can be done at the FB. My scrutiny panel are not going to oppose this proposition or have it referred back, but I would just ask members to look at Article 5(1)(a), which says, which will allow, if we pass this today, the construction of a track for the shared use of cyclists and pedestrians. And back in the 60s, if I ever rode my bike on the FB Fields, I did it, took my life in my hands, and I'd look over at the Constable of St John's, his wonderful uncle, Basil Choll, who guarded those facilities with his life and did a fantastic job. But boy, oh boy, you didn't dare ride a bike on the hallowed grass of the FB Fields. And I make a joke, but if we are to put a cycle track and a pedestrian facility through the FB Fields, there is no question that we will lose sporting facilities. We will lose the ability to play as much football as we do there. We will lose the ability to play as much cricket as we do there. And I say this, sir, because just running a little cycle track down the side of the touchline is not going to be possible. You can't possibly have a winger and a fullback coming in for a tackle alongside somebody cycling at 20 miles, 30 miles an hour. There's a lot of regulation, I think, that would have to separate the two. And so I just draw that to members' attentions. I'll just close by saying this, sir. I can see, as I said before, where the Assistant Minister is coming from. She's talking about unlocking the potential for the future. But in many ways, this also unlocks the safeguards that have maintained this facility, which is entirely for open air sport, and those grass pitches, which I worry will have to reduce in size if we end up with a cycle and pedestrian track through this wonderful playing fields. Thank you, sir.
Deputy Barbara.
Thank you, sir. And may I thank the Assistant Minister for the assurances that the proposition does not seek to amend in any way the covenant which relates to the Normandy gift. I'm sure that will give the residents around there a lot of comfort. But may I also ask the Assistant Minister to confirm, following this proposition, that all residents in the area will be fully consulted and provided any proposed plans for any changes of use and constructions on the FB playing fields. Thank you, sir.
Very much, Deputy. Deputy Scott.
Thank you, sir. Following on the subject of consultation, the Economics and International Affairs panel hasn't formally scrutinised this because this is basically as within the remit of the Environment, Housing and Infrastructure panel. However, we do have a role in scrutinising sport, and the proposition refers to the Inspiring Sport Strategy, of which there is no actual formal scrutiny, for which there is no formal scrutiny report. Having looked at this, I can see that there are tensions between various sports that could be played there, in particular cricket. There's this mention of this track. Rather like Deputy Ward, just from a scrutiny perspective, it would be useful to have some assurance from the Assistant Minister that in terms of the proposals for development of this area, that there will be some prior consultation with both scrutiny panels. Thank you.
Very much. And to have some bearing.
Thank you, sir. And perhaps I could begin by making the somewhat obvious comment that I congratulate the Minister or the Assistant Minister in contacting the family for their consent. I say that in the knowledge that some years ago a similar proposition came to the Assembly and no such consent had been obtained and the matter was sent back. So I'm pleased that you've observed courtesy and common sense on that. My second point relates, and I think the Assistant Minister already covered this, there is nothing in the proposition which says that any development will be subject to planning, but she has confirmed that it will be subject to the usual planning consents, of course, and that touches on points made by Deputy Ward, I think. I was on the Economic Scrutiny Panel at the time when sport was removed from the ambit of what was a Minister for Education and Sport. And at that time, we did express concerns as to the interaction between sport and schools in particular, and that, for instance, to take a obvious example, that a sport facility wouldn't be hired out to a commercial organisation to weekend when there was a rival claim by the school to which it belonged. And I think Deputy Ward's comments and concerns are very valid, and I simply wish to flag that or endorse the flagging which the Deputy has already made, that does need to be taken into account, and it may well be that some scrutiny function, whether in the Scrutiny Panel for Economic Affairs or Environment, might need to have further regard to that in the future. But those, sir, are my only comments. Thank you.
Indeed. Deputy Felton.
Thank you, sir. I feel like the Assistant Minister is asking the Assembly to place a lot of trust that in the government and how this change in legislation will be used. And I have a lot of sympathy for what Deputy Ward said with regard to consultation. And I would like to encourage the Assistant Minister to learn from the past where things haven't been done so well. And speaking as a representative for St Helier Central, I can use Springfield as an example of that, and recent changes of the use of Springfield. And I would encourage the Assistant Minister to learn from where consultation hasn't worked or hasn't been done previously, and absolutely I agree with Deputy Ward. I would like to get some idea from the Assistant Minister in her summing up what the overall vision is for FB Fields right now, because in this proposition I don't feel that it's clear. Whose vision is it, and what is the Assistant Minister's vision for this space? I know that inspiring active places is mentioned within what we have before us, but I also know that some people within the sports sector aren't actually that supportive of the vision within that inspiring active places documentation. I was pleased to hear the Assistant Minister make mention of the great work that the ground staff do. And I would also encourage that if there are going to be any changes in operating models, that people like the ground staff are not forgotten in that change. And I would also like further clarification from the Assistant Minister about what future potential uses may well be in the pipeline for the space, and who will be able to use the space. So, for example, if it is the intention that schools will be utilising FB Fields, will they indeed get access to those facilities when they need them? Will they be charged for those facilities? So there's still lots of questions that need to be answered before the government brings back any changes that they intend to make to FB Fields. But I don't see that as a reason to vote against this on the basis that I think the Assembly is showing their trust in the Assistant Minister, but also that the Assistant Minister will act in good faith and will respond to our questions, and also bring back plans in a consultative manner and ensure that residents, sporting organisations and other people that may well use it, such as schools, are well consulted. Thank you, sir.
Thank you very much indeed. Deputy Taddy.
Thank you, sir. First of all, it's good to hear the slight history lesson about where FB Fields come from. I think most people know it, but we often need to remind ourselves that a lot of the open green space that we have in the island is not here because of any benevolence of previous states' assemblies to want to give land or purchase land for the public. It's because it was given by wealthy philanthropists who had some skin in the game in Jersey to give over vast swathes of land. And it will be interesting to see if the continued high net worth programme, as the government likes to call these people, might be making similar donations in the future. We only need to think of Howard Davis Park, which was given to the island, which is still a beautifully maintained area with the hall attached to it for people to use. And we saw how that area was used just before Christmas, I think, or around Christmas, with the beautiful lighting that attracted lots of people down there who might not normally go there. And so it is also with FB Fields, which is for more pragmatic use for sports, but we mustn't forget the cottages that exist around there, which was part of the legacy of Jessie Boot and Florence Rowe as she was born, the Jersey girl who was born in town and married Florence Boot. So I don't think this is especially controversial. I think there have been some right comments to highlight here about what actually is going to be coming forward and the structures that exist. And I think Deputy Ward was quite right to put those comments on board, saying that I certainly also wouldn't want to see any kind of stealthy privatisation or incorporation of that area. One can imagine a scenario whereby a particular government might be tempted to effectively do what they've done with Ports of Jersey and, say, give over certain areas to Jersey Sport, let's say, for example, and then you find out that Jersey Sport ends up effectively owning these areas without necessarily the same democratic oversight that we might have had before. I don't think that's the intention. Perhaps the Assistant Minister for Sport can clarify that. But I know she's committed to sport, and I know that she's been very active in her first year in office, so I think it's worth congratulating her, and hopefully she can put some of those comments on record now as well about what she sees as a wider vision for this area, but maybe more generally for sport in the island. So I'm going to preempt some of the articles, sir, because one of the central reasons, central themes that's being proposed here is that we're being asked to legally validate a previously unauthorised construction of a clubhouse on FB Fields, and I think that might need to be addressed again in summing up in this part before she goes on to the articles. I'm sure it's a technicality, but you can imagine people listening to this debate thinking, oh, so it's all right for the states to give authorisation where there's been an unauthorised construction on their land, but if we'd done it on our land and hadn't sought the correct provisions and it wasn't done within the realms of the law, we might be asked to take that down, we might be fined, there might be all sorts of processes. So I'd like the Assistant Minister to address that and say exactly why it's okay for us to be doing that here, not simply just because it's been got the nod from the family. And I don't know if this is an appropriate time to say it, sir. We hear often lots of sports, the bigger sports get lobby groups, quite rightly. Football and rugby often come up, and there's a tension between which of those is the poor relation. We do have advocates for hockey, for cricket, and we don't seem to need advocates for golf in the island because we know that a lot of the island is already given over to vast areas for playing golf. And I don't necessarily have a problem with that. What I do have an issue is that there seems to have been a lack of basketball facilities, outdoor basketball facilities in the island. And I've raised this previously with the previous Assistant Minister for Sport, is that I would ask the Assistant Minister, is there going to be any provision for outdoor basketball on that site or anywhere else in the island? Because basketball should also be seen as a street sport. So we've had lots of discussions in the last few years about skate parks, quite rightly. And of course, skateboarders, and there have been some famous skateboarders in the island, find their skills and hone their skills by skating, which needs to be outdoors. You don't have to be a member of a club to be a skateboarder, but there's this feeling that if all of the sports that you effectively need to do in Jersey require you to be a member of a club, that may also, and therefore you need to physically access those spaces. I'm thinking about things like tennis, for example, whereby in the past in Llanelli, I know you could have just rocked up and started playing tennis outdoors because those courts were public. They're no longer public in that same way. And I think for youngsters who want to play basketball on their own terms, go out and shoot a few hoops, as the Americans would say, there aren't many places in Jersey where you can do that. And where there are outdoor basketball courts, they're often combined with other uses. So you have a basketball court with five-a-side goals inside, for example. I'm thinking of the Millennium Town Park. And if you started doing that for other sports like petanque, there'd be an outcry. So I just raised that issue here. It's not directly relevant, sir, but I think it's relevant insofar as we are talking about the future use of FB Fields, and I think this is something which hasn't been put in there up until now. And it is a multi-use site, and I think it is something which the Minister could consider, sir.
Very much. Deputy Conatable St Clement.
Thank you, sir. I just have to say that on behalf of St Clement's Parish, we're pretty comfortable with this. I was very lucky when I was first elected to be asked to a meeting with the ex-Sports Minister, the now deceased Deputy Hugh Raymond, who extended a welcoming arm a week after I was elected. And we went down to FB Fields and he told me what his plans were. Of course, I was as green as grass, excuse the pun, and I was delighted to be asked. It seems to me that this is a tidying up exercise. I'm quite comfortable with the way that the Sports Minister, current Sports Minister, is handling things. And if she isn't, we know now that there are many eyes upon her. As far as we're concerned, we are, as a parish, we want the green lung, which is in St Clement's, kept. We have very little space for our people, notably the Antium Homes and Lamare estate area. They haven't got much to play with. I would only say that if any buildings are going to be changed, they must obviously be retained for the sporting facilities for which they support. But they are hugely old-fashioned. And if that is not going to be the case, well then St Clement's will obviously react accordingly, as we did with the Greenfields of the Bridging Island Plan. We saw them off quite well with the support of our parishioners, and as we did with five-a-side football, with the help of the planning department and committee, we saw them off from the Normandy gift in fairly short order, although about 40 of them decided to appear and lobby us at the committee meeting. So we're on board. We want it kept virtually exactly as it is for sporting facilities for the island, and I am comfortable with the way that the sports committee and the sports minister is handling things, and if not, we are ready to react. Thank you very much, sir.
Thank you very much, Conatable. Deputy Alex Curtis.
Thank you, sir. And I'm very happy to be following the Conatable of St Clement, who echoed a lot of the hopefully optimism that we can have surrounding the continued use for sport and recreation by parishioners of St Clement, the east of the island, and the whole of the island. I have taken a bit of time in my mind recently wrestling the concept of covenants and gifts to the island and our future use of land. And I think, one of the things that's challenged me is, as an island, we've not been very good at utilising our land well, respecting the reasons we have our land, the reasons we were given our land. I think of the Lasea workshops and the Lasea gift, and I think, of course, about Deputy Tadia mentioning Howard Davis Park. I think of Howard Davis Farm. And I've just been spending time reading the abrogation of covenants on Howard Davis Farm, which I think was an opportunity squalid by previous governments without replacement of facilities such as agricultural research facilities. So I don't enter a scenario in which we loosen our ties to the public of the island and its use of land easily with the history. And in the region of sport, I think, previous governments proposed an Inspiring Active Places unfunded perspective that I felt was entirely out of keeping, out of scale with the proportions of what Jersey can afford and should be building. That said, I will be optimistic. I do really want to echo what Deputy Rob Ward said about privatisation. It is part of my belief and part of what I've discussed about, especially on strategic sites, the principle that the land owned by the public of the island is the land of the public of the island for the public of the island. And sites including, I'm sure a debate maybe once we'll be having on Mont de la Ville, on which of course Fort Regent sits on top of, is land of the public of the island. And I worry that sometimes we forget about how we best use this land. I will speak in the articles about what it means to construct and who should be constructing and who should be owning facilities on the land, because I think the devil will lie in the detail. For now, I think I will support the principles of this, but I look forward to a good, robust conversation in the articles, noting I would have hoped that we could have had a schedule of what would be suitable and not suitable to assure members. I look again at the abrogation of covenant on Howard Davis Farm, and there is a schedule of what is allowed on the site. What is allowed is sad and open and loose about light industrial and warehousing, and allows anything except almost agricultural research in that facility. But a schedule would have perhaps brought a lot of confidence to people about the future of this site, and maybe is something that the Assistant Minister can look into.
Thank you very much, Deputies. Any other member wish to speak on the principles? Deputy Renniff.
Yes, sir. I hadn't planned to speak, but it does give me perhaps a irresistible chance to reminisce about my time as an athletics athlete in my youth, when I was coached by Colin Campbell, who was just come back from the Olympics at that point. I was island champion for 200, 400, 800 and triple jump in 1 year. So I can get... Strangely, there's no plaque down there, but... So I did want to pick up on a couple of points which maybe have slight relevance. I'm a very strong believer in protecting covenants, and I think long and hard about changing or losing covenants. Partly that's a sort of a principle thing, but it's also a practical thing in that I think if we wish people to give covenants, then we need to show very great respect for the principles that were contained within the gift, and really keep living those principles and accepting what those principles are and what was asked for, because I think otherwise we might lose some of those gifts which are so important to the sort of the cultural and physical fabric of the island. But in this case, I think what's interesting is that the gift was given for sport and for that kind of activity. And sport has changed a lot since the 1950s and even since the 1970s. And if we think back to those times when you would have done sport, you would have probably got changed out in the open. And the idea of sport was essentially you kicked a ball around or you ran or whatever. And it wasn't it's as supported by the kind of infrastructure that you expect to see around sport. And indeed, many sports have a greater infrastructure demand now. And the sports we choose to play have greater infrastructure demands than in the past. So from my point of view, I'm comfortable that these changes stay within the spirit of the original gift. And I note that the Assistant Minister has made clear that the Boot family are also content. Two other quick points to pick up about the construction of buildings that are apparently in breach of the covenant. I would say the word was talked about them being unauthorised. I would have to check with officers, but I would be very surprised if they're unauthorised in the legal sense, in the sense that they will have had planning permits applied to them. I think the sense in which they're unauthorised is that they are in breach of the covenant, not that they're illegal in the planning sense. I will check that with officers, and if there is any update on that, I'll provide it. But I just wanted to clarify that, and also, therefore, to clarify that, of course, as the Assistant Minister has made clear, this is enabling law. We talk about may bring forward constructions. They will still have to be the subject of planning applications and be subject, therefore, to the normal consultation processes to ensure that whatever is proposed is fitting in with wider policy objectives and planning policies and so on. Thank you very much.
Does any other member wish to speak on the principles? Deputy Tombine.
Yeah, so I'm sure members will give this their full support, but I just wanted to take the opportunity to thank Deputy Stevenson for presenting the proposition so coherently, sir.
Does any other member wish to speak on the principles? No other member wishes to speak on the principles? Then I close the debate and call upon Deputy Stevenson to respond.
Thank you, sir, and I'm very grateful to all members who've contributed to this debate today, and I'm going to do my very best to address the points made in turn. I would also say that where the public is the beneficiary of a covenant like this, it's often the most practical and reasonable way is to vary or expunge it is by law, and that approach has the benefit of a number of safeguards, including, as we're seeing today, the political scrutiny that this assembly provides. So all the points very well made by members today are important, and I take them on board and know that officers will be doing so as well. So I really do appreciate that. Deputy Rob Ward started by questioning the nature of some of the buildings that may end up on the site, and as others did so, also mentioned privatisation and wanting some assurances from me. Now, that is absolutely not my intention here whatsoever, and as I think I made very clear in my speech, this is a very well-used, well-loved part of the sports facilities portfolio. This is absolutely about how we enhance that for the use of our community, respecting the covenants that are in place there. So, as I say, this is not about privatisation or overdevelopment, because as other members, I think Deputy Luce said later on about overdevelopment, and, you know, I absolutely recognise the huge importance of outdoor space for sport, and in an island of our size, we are often looking for where we can add new facilities like this. So the last thing I want to do, or those working in this area want to do, is to reduce that. This will still be a protected area. The Eastern Cycle Path was mentioned as well, and I think, you know, there are clearly challenges around the Eastern Cycle Path, as the Deputy pointed out quite clearly. This can be an important jigsaw piece in that puzzle. I think others then mentioned about not wanting to detract from sport at the same time, but it really would be not common sense to go ahead with something like this and not recognise that it can help with some of those challenges that we face. So that is why that's included. Quite where it would go or how it would work, you know, very much open for consultation and plans and discussions, but it could just simply go down the side of the land in question there. But as I say, that's all very much open. That's not what this debate is deciding today. I would also remind Deputy Ward that, and I thank him for the opportunity to do so, that we have a sports review ongoing about the sports delivery landscape, which exactly talks to some of the points that I think the Deputy raised around arm's length organisations and the provision of sport. And I agree with many of those questions that are out there, which is exactly why that report is currently ongoing and you know, is out for public consultation at the moment. People are able to respond to that, and we hope to publish something this summer. Deputy Luce, I think, on very similar themes there, talked about the dilution of the restrictions and wanted some examples of the kind of buildings that we could look at here. Now, this is small things like there's currently a shed for groundsmen on the site, which is really not in a fit state for our workers to not, let alone store their stuff, let alone sit and maybe have a cup of tea during their breaks as well. And so this law would enable us to look at being able to rebuild something like that if necessary. Currently, we cannot do that.
within the terms of this covenant. There's also some changing rooms along the side of the football pitches and cricket pitches, which are not considered to be fit for purpose in the modern day. Currently, we can't really do much about that. I would also, Deputy Lees mentioned cricket and football specifically, and I think the future of cricket at FB Fields is a conversation that we need to have more widely, and I know cricket in Jersey are aware of it, because as I mentioned in the speech, there are issues around cricket ball strikes down at FB Fields, and that's simply cricket balls being hit into people's gardens and beyond, and it is happening on a very regular basis. And this will always be a tension where there are homes and there are sports facilities as well. But as the great game has grown and perhaps strength has improved and maybe bats have changed as well, and they are going further and further, and we cannot build the fences high enough to keep them out of... Anybody who's been down to FB will see there are some very high fences there already, and I think the estimates that have been looked at put the need for those fences to prevent those safety challenges from ever happening would have to be many tens of feet high in the air, and I'm sure that's something that nobody particularly wants to see anywhere if we could even get the logistics of it to work. So there are challenges, and again it comes back as well to space and, well, where does the senior game move to if it needs to? Again, this proposition today isn't about that, but we do need to start considering that as well. I believe junior cricket and female cricket is currently working okay down there. So this isn't about getting rid of any of the sports that are down there, but we do have to take a very realistic look at how we are using the area as well. Deputy Barbara Ward, I was grateful for her repeating the Normandy gift, mention that it absolutely does not touch that, and as others questioned, you know, consultation with residents, absolutely, not just from a point of what would be proposed for FB Fields, but as the Environment Minister clearly stated as well, as part of the planning process, there are various opportunities for scrutiny and checks and balances along the way here. Deputy Scott talked about the Inspiring Active Places strategy, and just again wanted assurance that the proposals will be consulted upon. There is perhaps some confusion between the Inspiring Active Places strategy and Inspiring an Active Jersey. Inspiring Active Places talks about facilities, which comes under the remit of the Infrastructure Minister, and therefore not the Deputy's scrutiny panel, albeit there are important links there, and I will take that forward in future when I offer briefings to one panel. Perhaps the opportunity could be afforded to the other one as well there. The Connotables of St Mary talked about the interaction of sport and schools, particularly as others did as well, and this is a really, I think, a very timely contribution from him, because there is definitely opportunities and challenges there that we haven't addressed effectively in the past, and it's very much a live conversation with between colleagues across the various departments as well about how we can use the facilities that we do have across the island most effectively, but in a very balanced way that ensures, of course, that schools have access to them when they need them, but the community can use them at other times as well. Deputy Feltham talked about trust in government, and I think we've, over the course of the sitting for the last day and this morning, we've had lots of conversations about trust in government, and absolutely I'm asking that you trust us here. That's what we're doing every single day as governments, and then when it comes to ministers, as elected ministers chosen by this assembly to do exactly that. And I would seek to reassure the deputy that, you know, the vision for this is exactly as it says on the tin in here. It's about sports facilities for our community. And again, I think the deputy mentioned the Inspiring Active Places strategy. Now, that strategy was clearly written by a previous government, but also in a previous time.
And I think it's fair to say the world has changed quite a lot over the past few years. And we have reconstituted the Inspiring Active Places Board, and that board has met twice. I'm the deputy chair of it, and the Infrastructure Minister is the chair of it. I think it's probably fair to say we are looking at how we revisit that strategy. It may need some amends along the way. It is still very much exists, but the vision for FB Fields, we predict, will be part of those conversations going forward. There is no set out vision at this stage for FB. This is the first part in that jigsaw puzzle that was needed. Deputy Tadia, again, I'll just reassure members this isn't about privatisation. And I would also say that Jersey Sport does not run facilities. That's not what it was set up to do. So absolutely there is, I'd say there is not concerns to be around that, and privatisation beyond that. I'd just point to the comments I made earlier that I've set out. This is a very important part of the sports facilities portfolio that is run by government for the people of Jersey. Outdoor basketball facilities, while we're there, I think is, a really excellent idea, and I've had some interesting conversations with officers who are very passionate about this as well. And I absolutely, as the deputy said, refer to it as a street sport and recognise the huge opportunities there are to put something up quite easily, and often in small areas where there may not be other access to sports facilities. So I'd welcome a conversation with the deputy if you'd like to on that in due course as well. I also do know that it's one of the most popular sports among teenage boys particularly, actually, and when I went to Grainville School not long ago to look at their facilities, basketball nets had been put everywhere for exactly that reason, and they couldn't get enough of them. The Conotab of St Clement, I'm particularly grateful to him for his support and his engagement, both under the previous government and now on this matter. And I'm also grateful that he mentioned my predecessor, the former Deputy Hugh Raymond, because it was Deputy Raymond who signed the law drafting for exactly these changes. So this is not something that has just happened in the last few months. Deputy Curtis, I'm grateful for his optimism. I know that interest in kind of land and future development is a very important thing to the deputy, and so I'm grateful for his close scrutiny and again for his engagement early. We did brief the Conotab and the parish deputies a couple of months ago on this and seek their engagement before it was lodged as well. And I will look into what the deputy mentions around the schedule about what could be provided at the site. Deputy Reniff, absolutely, sport certainly has changed since the 1950s, and I think what the point of this decision would be today is to allow us to be flexible, not just for today's needs, but into the future as well. And the point very well made, actually, about that planning applications have to go in for buildings as well. It is also my understanding that the clubhouse, as mentioned by one of the previous speakers, would have received planning applications, so it wasn't unlawful, apologies, in those terms. Hopefully I have covered all the points made there, and I would just, seek to continue to engage with members and the wider community on the future of FB Fields, sports facilities more generally as well. I've absolutely made it my commitment since I took on this role to engage with the sports community on their needs and their interests and their views along the way. I have visited many of them and continue to do so, and the wider community when it comes to sport as well. Hopefully that can help to reassure members of this assembly that the aims of this proposition are to enhance sport and offerings for our island on this important site. And it will, if passed this law, respect the original gift and secure the continued use and maintenance of FB Fields long into the future. I'm grateful once again to the Boots family and
to the Conotab and the deputies for their engagement on this as well. I make the proposition. So.
Do you call for the appel?
Yes, please.
Well, the appel is called for. I invite members to return to their seats. The vote is on the principles of P27, Draft FB Playing Fields Jersey Law. Ask the greffier to open the voting and members to vote. Members have had the opportunity of casting their votes. Ask the greffier to close the voting. The principles have been adopted. 42 votes pour, no votes contre, no abstentions. Deputy Scott, presumably your panel does not wish to call this in?
That's correct, sir.
Very well. How do you wish to deal with the matter in second reading, deputies?
En bloc, please, sir.
Very well. Are they seconded for second reading? Yes. Does any member wish to speak in second reading? Deputy Rob Ward.
Yes, a couple of things. One that occurred to me during Deputy Renouf's speech, actually. In part 6, where is anything reasonably incidental, I wonder whether a statue to Deputy Renouf's achievements might be something, just we need to be careful about it. But on a more serious note, although that is not a non-serious proposition perhaps at some point. So I wonder whether I could ask, I need to ask the Solicitor General a quick question about Article 5, which is, it says the public of the island may construct. And I wonder whether that phrase, the public of the island, has any legal weight in terms of who may construct, i.e. does it have to be a states determined, or whether a private entity, it being given out to a private entity that may be not based on Ireland but may just build facilities of the type that have been built here before, may be something that is not allowed because of that wording. And it is a genuine question because it occurs on every section of Part 5. The public of the island may construct, the public of the island may maintain. That's even more important because who's going to maintain these buildings? So just I wonder if I could ask that.
Mr. Solicitor, are you able to assist?
I'll do my best. I understand the public of the island, well, it means exactly what it says. The land is owned by the public of the island, but the public's rights in terms of ownership and development are exercised by Jersey Property Holdings Limited, using, as I understand it, usually the infrastructure department's services for that end. So Article 5 doesn't give the legal right to anyone to do anything on FB playing fields in terms of construction other than the public of the island, which I take to be Jersey Property Holdings.
Thank you very much, Sister. Deputy Alex Curtis.
Thank you, sir, and actually that's helpful. I was going to ask the exact same question of the Solicitor General because I think that's the devil that I was going to pick up on. I would pick up on, under the same article, Part 5, that the public of the island may grant a registered contract of a lease. So I presume that would be a lease or contract that would be greater than 9 years typically, or something that could exercise a longer term. I do again think it's a shame that we don't have certainty over the length of time. You know, a lease could be a 99-year lease of a property in which you've lost your control of that. And I think actually the reassurance, and I think I can support the articles now under this firm understanding that if I understood, the public of the island cannot lease land to someone who can construct a building. So if I understood the Solicitor General, we can't lease a patch of land to an organisation who will then construct and own their facilities, for example, for a 99-year period, 199-year period. And that is a great reassurance, and I hope that reassures others. I would never want to see that changed on a site like this, and I would hope all agree on that. I also picked up on the part here about under the reasonably incidental to those purposes for the benefit of the public. Again, this is perhaps where guidance or schedule around what is reasonably incidental would support. I just think sometimes the ambiguity here either supports or hinders the aims and the principles we just voted and agreed on. Really, those were the points I wanted to highlight within the articles. I am immensely assured by that guidance. and would have probably, if I'd been given the guidance that the public of the island could give lease to land which could be constructed by another person, I will inform the Assembly I probably would have voted against it on those grounds. So I thank for the clarification.
Deputy Luce.
Thank you, sir. Just in a brief discussion with the Attorney General and Deputy Gorst about the Deputy Alex Curtis's leasing of land for building on, and I think it's slightly more complicated than he made it out. We certainly do have some people in Jersey who have buildings they own and they built on land owned by the states, but I'm not going to go into that. I just really want a couple of things. So the first one is something I want to get on the record. This proposition is brought by the Infrastructure Minister, therefore it falls to my scrutiny panel and not to Deputy Scott. I did indicate during my initial speech that we wouldn't be calling it in, so that's not an issue, so I just wanted to say that. And I just wanted to talk again briefly about Article 5.1 and the potential building of a track for the shared use of cyclists and pedestrians. And I note the Assistant Minister in the Principals debate talking about the difficulties with cricket, and it's absolutely right. As that great game changes, we are playing it in different ways and hitting the ball much harder and much further. But all the same, sir, I'm still concerned that the construction of a cycle and pedestrian track down the side of the FB Fields would mean the reorientation of football pitches and would certainly mean less football pitches available. So I just would alert members to that. It's not a game changer for me, but certainly Article 5 of this will need further scrutiny in the future. And as the Assistant Minister come back to the Assembly with propositions, or to the Planning Committee with propositions to construct or to develop, there'll be some more work to be done. Thank you, sir.
Thank you, Deputy. Deputy Tadier.
Thank you, sir. They say that great minds think alike, but they also say that small minds never differ, so I'm not sure which one applies. But when Deputy Ward was speaking, and in fact when my colleague from St Brelard was talking about how much of an accomplished sportsman he was in his youth, and I'm sure it's not just in his youth, that I realised how modest he was. I realised, I think somewhere along the line, I heard that he might have worked for the BBC making films, but I'm not sure about that. But I didn't know about his sporting prowess in his younger days. And I also thought that maybe the reason there's no plaque is because there's a statue being made of Jonathan Renouf somewhere to unveil at some point in FB Fields. And I think it does relate to Article 6. On a more serious point, about incidental building or facilities or things that might be put up there for the public more generally, it has to be said that we don't necessarily commemorate our sports people enough in that physical form. And it made me think that actually there is a very well-known statue of Bobby Moore at Wembley. So there's a statue of Bobby Moore. He's clearly a very well-known figure, and it's an appropriate place to commemorate him there for his achievements. And there's also a link between the statue and Jersey that not everyone might know, is that the sculptor who made that statue is Philip Jackson, who was also responsible for the Liberation statue and the Liberation sculpture that we know that stands in Liberation Square, which is very much, I think, one of the modern iconic images that we have of Jersey in terms of its identity, of our collective identity. So I would invite the Assistant Minister for Sport, and also in her capacity in infrastructure, to, at this point, sir, to give consideration, I think, as to what projects we might be able to have in the island in the public realm, because I think there is a great synergy between art and sport. We've seen it, for example, whenever Jersey's hosted the Island Games, that there was a great festival around that, a festival feeling, with some great music, if I recall, as well. Indeed, it was Howard Davis Park where the jamboree, if you like, happened. So I'd ask the Assistant Minister, in whatever capacity she ends up doing this, to be part of a wider conversation about how we might have more public art in the public realm, including, sir, FB Fields, including in sports facilities, maybe as part of a wider project for Liberation 80, which seems a few years away, but it will come to us very quickly, sir.
Does any other member wish to speak in second reading? No other member wishes to speak? close the debate and call upon Deputy Stevenson to respond.
Thank you, sir. And I'm grateful for the advice from the Solicitor General there at the beginning as well. Just responding very quickly to Deputy Luce on the track and the reorientation of football and others. Absolutely, I'll take all of that on board and welcome the ongoing engagement, not just with scrutiny, but beyond. And I'm sure we can encourage officers to start thinking about that sooner rather than later as well. Deputy Tadier, just while I've got the opportunity to go off on a slight tangent with some of the points raised there, I would absolutely agree that we don't commemorate sports people enough. I don't think we commemorate lots of people in our community enough, particularly women. And I know that the Deputy and I have had a number of conversations about how that could be improved, and perhaps we should continue those. I'd also add to it, perhaps we should also revisit the discussion of a national anthem for Jersey, because I know that a lot of sports people that I speak to do recognise a certain song as their national anthem and actually get quite upset that it's not recognised officially beyond there. There is a great synergy between art and sport, and I think it's actually one of the real strengths of where sport policy does fit within our government system, with economic development, tourism, sport and culture currently. So great minds do indeed think alike, Deputy Tadier, and I will continue to work on that basis as well. I'm grateful for everyone's contributions today. There's a lot of food for thought there as well. So I propose them en bloc, sir.
Very well. Those in favour of adopting en bloc, kindly show.
Oh, please.
That is called for. Invite members to return to their seats. The vote is in second reading, and ask the referee to open the voting and members to vote. Members have had the opportunity of casting their vote, and ask the referee to close the voting. The articles were adopted in second reading, 42 votes for, no votes contra, no abstentions. Do you propose in third reading?
I do, sir.
Are they seconded for third reading? Does anyone wish to speak in third reading? All those in favour of adopting in third reading, kindly show. Those against? Well, the law is adopted in third reading. Very well. In the light of the decision taken by the Assembly earlier, we now move on to the provision of a free hopper bus for active card holders to Springfield Stadium, P33, lodged by Deputy Ward of St Helier, the main respondent being the Minister for Infrastructure. And I ask the greffier to read the proposition.
The states are asked to decide whether they are of opinion to request the Minister for Infrastructure to instruct Liberty Bus to enable free access with immediate effect for the town hopper bus for active card holders travelling to Springfield Gym and exercise facilities for an initial trial period to 31st of December 2023.
Deputy.
Thank you, sir. I'd like to start by just reiterating what this proposition is. It's a very simple proposition. And I'll just reassure members, I have a number of bits of paper in my hand, but it's quite large font, so don't worry. The proposition, sir, is about a trial, a temporary trial for the hopper bus, a service that already exists for active card users who already hold cards or already pay money to the government and who had free parking up at the fault with their active card, which is no longer available. That's the beginning point. But I do, unfortunately, have to address the comments paper produced by the current Minister for Infrastructure first, because the initial tone was this was not a very well thought through idea. So I'm going to go through each of those comments and address those more appropriately. So first of all, the first point was about we do not run Jersey buses as a reasonable, and the fact that it's a contract. And I'll combine that with the second point where it says the Townlink bus service is operated under a fixed cost arrangement where Liberty Bus are paid an agreed sum to run the buses. Now, in questions the other day, there was no answer as to whether the money given for the town hopper bus was a set amount just to run the service or whether it was paid per the number of people using the service. So already we're unclear as to whether the validity of that comment. Also, sir, I would like to say that what we do need, if we're going to make assumptions and make a decision on whether this service is, we can use this as a trial and the cost of it, is to know how much Liberty Bus is costing us and how much we spend on it. So I would like to ask the Minister that when he speaks, he does tell us the amount of money spent and given to Liberty Bus. Now, the reason I say that is because in a written question 164/2023, April this year, in the final paragraph, it was stated, while there is a need for transparency, we've heard that word a few times today in this sitting, sir, and to provide information to states members, the information requested is currently commercially sensitive. Now, I think there's a very important point to be made here, because if the amount of money given to Liberty Bus is £500,000, you might say, well, you know, running this service for free is really not good for them. But if it's £1 million, we might think, well, adding a little bit of the service on isn't so bad. If it's £2 million, we might start to think differently. If it's £3 million, we might start to think, well, what are we paying for? And why can we not start a simple trial for a bus that already runs? If it's £4 million, we start to move beyond that and think about why the service isn't free in the first place. If it's £5 million, that becomes even more amplified. If it's £6 million, or even around £6.4 million, then this simple proposition to ask for the town bus to be made available for a trial period, and we've heard that the town hopper bus is not being used very much, so it would be an excellent opportunity to promote it and increase its use. So if we are spending a vast amount of money on our bus service, all of which is going off island, by the way, the money is going off island to a company that is not owned here, then we need to know how much that money is. So for the sake of transparency, sir, I would ask the Minister to say that in the speech to help with the decision-making of this Assembly. Now, point 3, sir, says that I have produced no evidence. Sir, absolutely. It is impossible for me to consult with every individual active card holder as an individual deputy in St Helier Central. Absolutely impossible. But this trial, and remember it is a trial, will produce evidence and collect data that we've talked about so much in this Assembly. Data, data, data. We're going to collect so much, but we don't do anything with it. This is taking the opposite. This is saying let's create an opportunity and enable people with a service that already exists, with a card that they already hold, and a specific reason for travel, so that we can produce that sort of data and say, actually, this is a really good idea. And this could actually cut down the traffic in the area. Now, it was mentioned, and also, sir, there's this point in point 3, the argument that it prevents active travel it prevents active travel. So this is a red herring of the size which should be mounted onto a mantelpiece, sir. It comes up on every single debate over the use of buses that we've had. And I've had quite a few in the last few years. Indeed, sir, I remember, sir, the last Chief Minister referred to me as being obsessed with buses. That's unfair, sir. I may be obsessed, I don't know, obsessed with drums and the correct way to stack a dishwasher, sir, but that's a relationship issue. We shouldn't go into that. But so that exact same argument was used in the under-18 bus pass, and that has been a resounding success. And that is changing, I believe, the travel habits of young people on this island and extending it, supported by the government, in the government plan, so that all those full-time students is exactly the way forward that we should take. And we took that step this time. This is an opportunity to trial another example of doing that. And bit by bit, drip by drip, we increased the use of our bus service in an appropriate way. Point 4, so there was not a bus at the Fort Regent. Yes, absolutely, correct. However, there was ample parking, which was free to use with your active card. So there was provision made to get there. And the bus service, the town hopper, does go past 2 car parks. And if we thought it through and we saw it was working, the sensible thing to do would be to say, okay, how can we move it so it goes past more? We make our own mini little park and ride through the centre of St Helier. So point 5, which is, I need to look it up, so I just mentioned point 5. Peak times gyms use is understood to be before working hours and after working hours. That may well be the case. Well, then change the Townlink bus if that's seen as it becoming popular. But it will take some people out of their cars during the other times during that day and at weekends. And so one of the reasons I brought this to the Assembly, because the constituents that we have in St Helier Central that we talk to all the time, and my drop-in is at Springfield, by the way, every Monday, 4:30 till 6, a little bit of a plug there, sir, that when people come and speak to us and residents talk to us, there have been times when, at a weekend, when there were events going on, there were school events going on, people using the gym, the area was gridlocked. There was nowhere to park, and we as Central deputies get the questions. Now, this isn't going to solve that, but it's one ingredient in perhaps moving towards a solution and understanding the traffic flow in that area. And this is why this simple proposition, I think, should be supported. And yes, it's not at peak time, but other times, particularly in bad weather, we've got good weather at the minute, people probably are walking and cycling, excellent. But this goes up to December, this trial. And I think it'd be very important to trial this through the winter months when the weather changes, people still want, in fact, more indoor exercise, and traffic flows increase. Also, sir, there's no intelligent approach that's been taken here to say, let's communicate more with people in the area and say, actually, on Saturday, I'll make this date up, sir, the 12th of July, there are 4 events going on from schools. This is a red time to take your car to that area. And if that was to happen, and you could say, however, if you are an active card user, you can take the hopper bus from this car park, you are educating, communicating, and you are driving behavioural change. Now, we've heard this before with other areas, such as subsidies for electric bikes and other subsidies, that we're just giving a little push to shift behaviour. And that is one of the arguments made. But it seems to be not accepted for something for the centre of St Helier, which I think is a real shame. Point 6, there are parking spaces that have been provided, which is slightly contradictory to the argument against not promoting active travel, but we won't go into that. However, sir, that area has an air pollution problem that is not being dealt with. Written question 242 in 2023, when I asked about air monitoring. That's what I'm obsessed with, sir, air monitoring around the area. I'd accept that obsession because it's very bad for our health. There is no monitoring of health quality around that area. And so therefore to unilaterally increase the traffic flow to that area without anything else put in place, such as the free use of the bus that exists for a trial period, I think is irresponsible and should not have been actioned. Point 7 of the comments paper. So I am not suggesting that other services are included. Another red herring. And I urge the members of the Assembly, please don't get drawn down these rabbit holes of inconsequential arguments, sir. Because I'm not suggesting other buses are included. This is about the town hopper. And part 8, no evidence that the town hopper bus acts as a barrier. The fare on the town hopper bus. Actually, sir, the town hopper bus is not being used. The town hopper bus costs £2.20 for a single journey. The through fare is not being promoted. And it was said yesterday, sir, in the debate, that we're not entirely sure even what people are using it, who they're using it, and whether the cost is added to the running of it. So it's just simply not being used. This is an opportunity, sir, to advertise that to a number of active card users, to a captive audience. You have their emails, we have the GDPR requirements to be able to contact them, we have them, we see them, we know where they're going. This is a way to promote that town hopper bus and its use. It's already running, it won't cost you anything else. And so it says it does not come at zero cost. I go back to my original point. Then tell us how much we're spending. Tell us how much we're spending for the entire bus service. And this tiny proportion, would it be reasonable for us to go to the supplier of our bus service and say, we are giving you X amount of money. We want to try this trial. It will promote the service you have. We will come back afterwards. I don't think that's unreasonable at all, unless we're just saying we have no control over our services on the island, which I think is unfortunate. So I asked the Minister to tell us how much is being paid for the bus company, that it's good value, where the profits go, and the service. And without this detail, we cannot accept the position that this is untenable financially. I'm afraid that is an inconsistent argument, and we must dismiss it. And so I finish off by saying that this is a trial. The local deputies, and in terms of consultation, it would have been great if we would have consulted. You're absolutely right. When the changes to Springfield were proposed and we went through in detail with our meeting, but unfortunately that meeting never happened. The consultation didn't happen. Deputies weren't called in. We're not involved in the active travel places at all. The deputies in St Helier are absolutely not included in these things. And so don't be surprised when I come to this assembly and say, let's take some action to make some small change. And certainly, sir, it should not be negated in the way that this comments paper has. So I urge members to enable this trial and provide possible future improvements to travel options around Springfield. If it doesn't work, it doesn't work. If it's not successful, it's not successful. Then we stop it happening. But if it is successful, like the under-18 bus pass, like the full-time student bus pass will be, because it changes people's behaviour and encourages them to take a different way of travelling, then we can continue and we can improve the quality of travel around that area, and we can change people's minds about using public service. So with that, I make the proposition and I ask members' views. Thank you.
Proposition seconded. Does any member wish to speak on the proposition? If not, Colin Harbson, Helier.
Thank you, sir. When Deputy Ward previously proposed a subsidised scheme for the Hopper bus, I earned his indignation and wrath for some time by opposing it. And I opposed it on the grounds that if we have a certain pot of money to promote sustainable travel, then we need to use it wisely, and putting all that money in the bus companies' pockets doesn't help the people who find cycling in our island difficult and dangerous, and it doesn't help the people who are trying to walk to work or to school or to the shops, who still find, incredibly, a very difficult walking experience, particularly in our town so congested with traffic. And I felt that that money should be spent wisely and carefully to make sure that the most vulnerable road users, those walking and those cycling, their needs were addressed before the needs of bus travellers. And yet I'm going to support Deputy Ward today, and hope if he hasn't forgiven me for my past position that he will forgive me now. And I'm going to do that for two reasons. The first reason was that my logic in saying the money must be spent on other forms of sustainable transport hasn't seen, as far as I'm aware, any dramatic increase in spending on walking and cycling. There is still no strategy for walking, safer walking in this island. There's no strategy for safer cycling, responsible cycling. There's no parking strategy. There's no bus strategy. And I know that it's a new minister, and I've discussed these things with him, and I know his officers are short-staffed, and I know that he's working on bringing forward these strategies. But I'm afraid people's patience is limited, and we can't continually promise jam tomorrow to the residents of St Helier who find traffic in particular blights their lives. So that's one reason. I have to say that my ability to wait patiently for these strategies and these improvements has really run out. The second reason, sir, is that since March this year, I've become the proud possessor of a senior citizens bus pass. I got it on my birthday, and haven't used it as much as I would have liked to have done, particularly because living in town, I don't really need to, and I try and walk everywhere or cycle everywhere. But on the occasions I have used it, I've been absolutely amazed by the number of people who are taking advantage of the scheme that Deputy Ward's previous proposition ushered in. It really is making a difference to the way young people travel around our island. So I think he was right, and that's why I'm going to support him again today, because I think this is right. And as he said in his excellent speech, opening this subject up, and I think really demolishing the ministerial response very effectively, this really will make a difference. It's a trial, and we ought to get behind it. Thank you, sir.
Does any other member wish to speak on the proposition? Deputy Feltham.
Thank you, sir. I too was quite surprised by the tone of the comments paper. I found it quite disappointing, to be honest, from the Minister. As a party, as a team that works together, we do provide challenge to each other when we're thinking of bringing in propositions, so that we think about the pros and cons of what we're doing and whether it's the right thing to do. And Deputy Ward actually had to convince me that this was the right thing to do, because I want actually us to go further with regard to the hopper bus. I think it should, the routes should be expanded, and I actually think it should be free for everybody. But what convinced me was Deputy Ward said to me, well, we've got to do something. Doing something is far better than doing nothing. And what the Deputy's proposition does as a pilot scheme will also enable ministers to collect data. We've heard very often from government that they want to act on the facts, act on the evidence, act on the data. And actually enabling active card users to use the hopper bus for free as a pilot, and a short-term pilot, does enable us to see whether free use of that particular service will lead to change and will drive a change in the way that people get around town, and does enable us to look at whether park and ride schemes, encouraging people to park further out and then use bus transport to get to where they need to be, will actually work. And I hope actually the Minister would also use the time of his review of the hopper bus to look at different route networks, and also to look at expanding the operating times of the scheme. The Constable talked about how fed up people in St Helier are. I wholeheartedly agree with that, and I was only talking with some constituents who live on Great Union Road last week, who pointed out to me that the hopper bus currently doesn't go up and down Great Union Road, where actually lots of pensioners live. They also said that they and their friends hadn't used the bus because the day that they wanted to use the bus was a Sunday and the bus wasn't operational. So there's lots of improvements that can be made to this service, and I hope that the Minister's review leads to improvements of the service rather than stopping a service which I think, to be honest, may have been set up to fail. Set up to fail perhaps because it came as a proposition from Deputy Southern, and perhaps officers and the department didn't want to implement it in the first place. So maybe they put less time and thought into how it would be successfully operational. But now's the time to put that time and thought in. Now's the time to make that service better. Deputy Ward has identified an issue created by an act that the government made in changing the use of Springfield, bringing more people into that area. It's already a congested area, and I also add that that change to the use of Springfield happened at the same time that Lamott Street was closed for road improvements as well, which has further added to traffic congestion around town. And that's why something needs to be done now. That's why something that's a small, simple step in the right direction is the right way to go, and exactly why I will be supporting this proposition. But I guarantee that we will also bring future propositions, because we know this doesn't go far enough. We know that we need to look at expanding that network. People from Lepukale, for example, may well use a hopper bus to come into town to work rather than driving. And for me, we need to have free transport within town. One of the most interesting things for me about the comments paper was actually what it told us about the contractual obligations between government and the bus operators. And I was quite surprised to read that the government seems to think that its hands are bound in what it can and can't do with this very important public service. I was even more surprised given the fact that this operator also operates services in Perth, which I was lucky enough to visit in Australia over the Easter holidays, and where I used to live, and where they do operate a free transit zone within the city centre, and where the government has only recently implemented a cap on fares. So people who would have previously been paying to travel through 5 zones of the suburban area, the fare is now capped at 2 zones. Now, that's the action of a government that wants to see progress on public transport, and that's exactly the type of action that we as an Assembly should be taking. So I urge the Assembly to support the Deputy's proposition.
Does any other member wish to speak on the proposition? Deputy Luce.
Thank you, sir. I rise in response to Deputy Feltham. The one word I wrote down when Deputy Ward got up to speak was this: simple. He started by saying, this is a simple proposition, and immediately my ears picked up and I thought, no, it's not, because anything that is, there's always a devil in the detail. And I think we've heard, yes, we know today is just about the free service for those who enjoyed free parking at the fort and want to continue to go to the gym at Springfield. We know that's not turning out to be working well, the area's gridlocked, but Deputy Feltham's just raised the issue of, her constituents in Great Union Road. I went to think, okay, so maybe that would be Shudner Street, Poona Road and Aquila Road. Before we know where we are, everybody in town will be demanding a free or hopper bus service on a Sunday. And then, as she said, it might go to Le Marais or to the Skye, where you've got increased numbers of people living, because that was the reason, where a lot of older age people living. And it will expand, and yes, I know that Deputy Ward's proposition today is very simple and straightforward, but it will lead us to the next stage and the next stage and the next stage, which would potentially end up with a complete free bus service for Jersey, which would be a massive debate, but maybe it's one that we need to have. I don't know. If we want to get people out of cars, we've got to find public transport working more frequently and at a cost that people find attractive. So I just say that, sir, I was alerted by the word simple. I don't think it's quite as simple as Deputy Ward makes out, but let's see where we go with this. Thank you.
Very much. Constable St John.
Thank you, sir. Yesterday we had a couple of questions about bus travel, and in one, Deputy Ward invited the Minister to join him on a bus for a photo shoot. My immediate thought, sir, was of Reg Varney and Blakey. You'll have to work out which was which. So 2 weeks ago I was in Quimper and witnessed a small electric bus running around the city on a very regular basis. The few that I saw had good ridership, unlike our current trial. I was very happy to support the young people trial, as I thought it was one of the best ways of getting people used to being on a bus, train them young. Like the Constable of St Helier, when I am on the bus, I see many youngsters using them. And as importantly, speaking to parents whose youngsters are using the bus, it really is a positive experience, both for the youngster and for the family as a whole. So Liberty Bus continue to do an excellent job, in my opinion, and we should work with them to make a hopper bus work well. Only last week, the deputies in the district and the constables in our district were talking about across the north of the island bus, and we're going to try our hardest to get that. So Deputy Tadyer in the previous debate spoke about Jersey 2015. One of the successes of that week, sir, was a hopper bus. A hopper bus operating out of the bus station, linking the majority of sports venues and hotels from the FB to Lepukale ironically including both Springfield and Fort Regent. It wasn't without fault, and certainly lessons were learnt, and if I was giving advice to someone who was going to organise that in the future, I would tell them to do it differently to what I did. The Constable of St Helier mentioned a walking strategy. So why don't we have walking maps for St Helier, a guide to tell you how far you can go in 5, 10 or 15 minutes? I think the points raised yesterday are actually more of a priority, in as much as we should be targeting people all around the area covered, rather than just a small group of users. Small steps, sir. If we encourage active card holders to use this bus, they may become ambassadors. They may tell family, friends and colleagues about the benefits of this route and indeed the benefits of being on a bus. Having spent many, many evenings at Springfield throughout the year watching one of my sons play football, I'm fully aware of the congestion in the area before the changes were made, and I'm fully aware of the issues following the changes. It certainly hasn't got better, and anything that we can do to alleviate the traffic in the area should be explored. In my view, sir, we should be doing far more to promote the use of buses as part of our cost of living drive. It can be much cheaper to use a bus than to use your car, let alone all the environmental benefits. And as it's a trial, sir, I will be supporting the proposition. Thank you.
Very much. Point up. Does any other member wish to speak on the proposition? No other member. Deputy Stevenson.
Thank you, sir. I sympathise greatly with the Deputy when he says that he can't consult with all active users, and absolutely I can't expect that. But I really am struggling to find any evidence that this is needed or how it can make a very practical difference in the ways that he suggests. And in coming to that conclusion, I've looked quite closely at how this would work practically. So just doing a few quick searches on Google Maps, not my own timing, I would have to say. From here, if I was looking to go to the gym at Springfield, it predicts a 16-minute walk or an 8-minute cycle. On the closest, on the bus that the Deputy's proposition is speaking to, and the proposition is quite specific in that it talks about the bus that stops outside the facility. Now, there's 2 Town Link bus routes, as far as I'm aware, and it's the Route 20 that stops outside Springfield. So if I was to get on that bus from, say, Broad Street as perhaps being the nearest stop from here, it's around a 9-minute journey. So, you know, there's 7 minutes in it if you're walking. It's actually quicker to cycle if you can, but I do appreciate you'd then have to put your bike in, lock it, whatever, either side. So when we're talking about if it's to do with time, I'm not sure it is making a great deal of difference to people's time, particularly when you are then stuck with the times of the bus. Now, speaking of the times of the bus, the Route 20 does not start until after 9 a.m. in the morning. And the first bus, I believe, would leave around 9:27 and get to Springfield, as I say, around 9 minutes later. The last bus on that route arrives at Springfield at 4:56 p.m. We know that most people, or the vast majority, and I do apologise that I don't have an exact number, use the gym before work or after working hours, and actually the gym is quite significantly quiet during the hours of 9 till 5 when this bus would be running anyway. So you can see where I'm going, that I'm starting to question just how many people this would really start to impact on. I would also just like to point out that we've heard mention a couple of times of active users having free parking up at Fort Regent. What those speakers haven't clarified is that those active users do still have now access to a car park area at Springfield, the Gyratory car park, which sits across the road from Springfield as you're going around the one-way system, has been designated for active users. That was taken back as part of the move to Springfield. It was previously rented out to residents there. So there are a number, I think it's 40-something spaces in that car park there. So this is not a case of taking away free parking that existed at Fort Regent and not providing an alternative. There was an area at Fort Regent and there is an area of free parking. So when it comes down to cost and free spaces, again, you can see that I'm struggling to see quite why this is needed here. The other point I would like to make is that there are lots of people that use Springfield. We have the gym there, of course, and I will remind members that this isn't a debate about whether you like the new gym at Springfield or not. It's about providing free access to a bus service for a certain group of people. But there's lots of people, more people using Springfield as well. There's parents dropping their children at the nursery that's there. It's the home to the JFA, and I believe around 1,000 people play football there a week. It's the home of Jersey Bulls. There's a very well-used community cafe, a play park. There's the Blue Room upstairs, which is used by all sorts of groups, including, I think, like exercise referral type organisations as well. This proposition singles out just one group within that, and as I've said from the practical elements, this would be one very small group. So I'm really struggling both to find the evidence that this will make a difference and also on the fact that we're singling out this one group of people. Now, if Deputy Ward was asking me today to support free buses for everybody, everywhere, I may be speaking very differently. But we're not. This is about one group of people, potentially a very, very small in number group, having access to a very specific route at some times that I really do question whether it will make any difference in the way he suggests at all. So for those reasons, I will be opposing the proposition and would urge others to as well. Thank you, sir.
Any other member wish to speak on the proposition? If no other member wishes to speak, Deputy Tomine.
I'm not a particularly competent orator, but I shall do my best to address the points that have been made. As I mentioned yesterday, I support travel by bus and actually use the bus frequently myself. But one of my key objectives is to continue to increase traveller numbers and the number and frequency of routes. But unfortunately, sir, this proposition doesn't support these objectives. I certainly admire Deputy Ward's commitment to environmental objectives, and I know that we share the same objective of getting more people onto the buses. But I would suggest this proposition isn't the way to achieve that aim. On the one hand, I don't believe it's well directed, and on the other, I think it's unwise in principle. The proposition asks that we make the hopper bus free for active card users. Sadly, sir, the hopper bus doesn't travel outside of working hours, which is when most people use the gym. Springfield Stadium is actually served by other buses that bring people in from out of town, and yet this proposition doesn't seek to ask for these buses to be free. So, if approved, people in town within walking and cycling distance will be able to get a free bus to the gym, but those who live further afield won't, and that doesn't make sense to me, sir. The way to get more people onto our buses is to make buses more frequent across more routes. It's really all about convenience. It's also about price differentials, so that when people compare the costs of using a bus rather than going by car, they're tempted to choose the bus. But that shouldn't mean free. Free buses reduce revenue for the bus operator, which reduces the resources available to be invested in new routes, and that's contrary to our objectives. I certainly don't believe this proposition will increase the number of people going to the gym or increase the number travelling by bus to the gym, and I don't see any evidence to suggest that it will. There was never a public bus route to Fort Regent, and no calls for one, certainly not as far as I'm aware. Springfield is also well served by those wanting to drive. As advertised on the Active website, there are actually separate car parking areas, including the facility adjacent to La Petite Route de Valplaisant, which offers 43 new spaces reserved for active permit holders. And overflow spaces are available at Springfield School after 5 p.m, weekdays and at weekends. So we live in the real world and need real-world sustainable solutions, ones that use our money wisely and achieve our objectives. Fundamentally, we should be aiming for a low-cost fare model, not a free model. This supports investment, which supports more buses. This is a realistic and sustainable business model. Using the carbon neutral roadmap funding, we've added new services to existing routes and new routes where evidence supports potential shifts from cars to buses. I've got a list of them here, sir, but I don't intend to try people's patience by reading them all out. So we need to deliver a step change in modes of transport from the car to the bus, but I don't believe this proposition achieves that. So I was asked to quote some numbers about how much we actually pay Liberty Bus. We don't actually pay a block sum to Liberty Bus. What we do is subsidise individual sections, such as the town hopper bus, transfer tickets, young persons, disabled, and senior citizens. So I'm afraid perhaps I'm not as on top of my brief as I should be, but I don't carry those figures around in my head. I'd certainly be very happy to make those figures available to Deputy Ward. I do fear, sir, that this is the thin end of the wedge, because if we're going to support people going to the gym, and I've used the gym for 30 years, my brother used to go to the gym, and he lived 2 miles away. He used to put weights on his back and run to the gym, do his training and run home. Actually, the gym is essentially a place for people to get fit, and there's nothing, in my view, wrong with people walking or cycling to the gym. That's the whole purpose of it. If we accept that, if that becomes an acceptable precedent, then why not going to the cinema, going for a meal? We're well on the way to having a bus service. If that's what people want, that's another matter. But I think to go down this route and to start here really isn't the place to be. So I would urge people to reject the proposition, sir.
Thank you very much, Deputy. Before I call on you, Deputy Mezek, we have about, I think, 4 minutes before standing orders require me to ask whether we go ahead. I'm conscious that obviously Deputy Ward will wish to answer. So could I get an indication as to any other members who might wish to speak on this matter? If you could light your lights now. Very well, there's at least another 3 and 4 including you. So I think I'll at this point ask members whether they wish to continue with the hope to finishing the debate before the luncheon adjournment, or alternatively to adjourn until the adjournment is proposed. Is that seconded? Does anyone want to speak? No. Very well. The Assembly stands adjourned until 2:15.